come back. The Senate will come back to order. Senator from the 20th. You ready? Your bill's up next. Secretary will read Senate Bill 210.
Senate Bill 210 by Senator Tolleson of the 20th and others. A bill to be entitled an act to amend Title 12 of the OCGA relating to conservation and natural resources so as to repeal Chapter 6A and for other purposes. The Senate Committee on Natural Resources and the Environment recommends that this bill do pass by substitute. The Senate Committee on Natural Resources and the Environment offers the following substitute to Senate Bill 210. A bill to be entitled an act to amend Title 12 of the OCGA relating to conservation and natural resources so as to repeal Chapter 6A relating to land conservation and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 20th present the bill.
Thank you, Mr. President. This bill here is really a kind of a little rewrite of the land conservation program that we already have in the state, and it'd be called the Georgia Legacy Program, and it would have the same parts of it. It'd have the Georgia Legacy Trust Fund and the Georgia Legacy Revolving Loan Fund is what they would be called now, and GFA would administer this the dollars just like they do now. But it does create 5 different categories out there. One would be to acquire critical areas for clean water, game, wildlife, natural resource-based outdoor recreation. Number 2 would be preserve working farms and forests through voluntary conservation easements or acquisitions. 3 would be aid in the acquisition and improvement of local parks and trails. 4 would be provide stewardship of conservation land, and 5 would be promote land usage for health and wellness programs. So this actually sets up 5 different categories. It does what the current land conservation program does, but it sets up more categories also, because as we move forward and we change, all these other things have been coming into play in the state of Georgia. So anyway, it's not a there's one thing that was out of it that the House wants to put back in, I believe, and was the checkoff, income tax checkoff for Georgia Land Conservation Trust, and that would be, then it would be changed to the Georgia Legacy Trust Fund, name-wise would be changed, but that's probably going to, the House has said they wanted to add that back in, so I'm going to let them add that back in. But the bill basically just is like the land conservation program we have, but it does set up 5 different categories because we got a lot of different things that we do now. You know, if you probably look here at the metropolitan region, a lot of these things come into play. And so with that, Mr. President, I'll be glad to take questions, or I'll yield the well and ask for your support on the land conservation program.
Senator, you do have some questions. I would ask you for a moment to exit out of the well just for a second, if you would, please. Senator, just exit out. I'd like to have a Senate's attention for just a moment. It's very, very rare that we get to recognize someone who not only serves this body, but also serves as Secretary of the Senate and happens to be 80 years old today. Believe it or not, Miss Frida Ellis, who's here. Let's give her a round of applause. All I can say is this is the new 60, huh? Maybe the new 50, I don't know, but it's great to see you. You're doing great. Great. We love Miss Frida. Does a great job and always has a wonderful smile on her face. Senator from the 20th, you can come back to the well and take a few questions.
All right, Mr. President.
Chair recognizes Senator from 33rd for a question.
Does Senator yield for a couple of questions?
Yes, sir.
If you would look with me on the substitute on page 2, administratively, the fund is attached to the Georgia Environmental Finance Authority. Is that correct?
That's correct. Just like the one is now.
And could I, if at any time would, I'm not sure about the one now, is it not true, but I'm asking you if at any time would the Environmental Finance Authority be able to issue bonds for these purposes?
I don't believe so. The state may do some bonds through the budget process for it, potentially. I mean, there's potential there, but basically they're holding funds that are given to them through the budget process or that people are donating to the funds.
All right, sir, would you yield again?
I sure will.
If you look down at number H on page 2, it lists some of the types of things that can be conservation. And number I says provision of recreation in the form of boating, hiking, camping, fishing, hunting, running, jogging, biking, walking, or similar outdoor activities.
Yes, we put that in there for you, Senator.
And yeah, thank you.
That jogging.
Thank you. If you look on the next page, Senator, if you'll yield again. Yield.
Yes, sir.
At the bottom of the next page, it said owned by any person or not-for-profit or for-profit entity.
What line are you on?
I'm on the last 2 lines of page 3, 95 and 96. Do you see that?
Yes, I do.
Last 2 lines. Any entity not for profit or for profit.
You on 97 and 98? On what
95
page?
and 96 on page 3.
On page 3?
Yes, sir.
Okay. Okay, what is your question to that?
Well, what I'm asking is you've got these types of activities listed in biking, camping, hiking, fishing, and these types of things, which many times are owned by private entities. And then you've got private entities, for-profit private entities listed on line 95 of page 3. My question is simply, is there any room here, especially considering the language on page 5, whereby a private entity could abuse this fund?
I don't really think so, and the reason is the council that has to approve these, the Georgia Legacy Council, who has the DNR commissioner as the chair, the state forestry directors on there, the soil and water conservation commissioners on there, and state property officers on there. And these are, they look at these programs and they decipher them before they ever agree to let them occur. So I think the check and balance is in the committee.
Do you yield for one more question?
I do.
Senator, if you look on page 7, there is a provision 12.6A7. And not to read it all, but it says in the last several lines, to ensure the permanent protection is contemplated by this chapter, the grantee would then be entitled to resell the land to private parties at the highest obtainable price. And those proceeds would go back to the fund for additional grants. That language, with the language I mentioned to you before, gave me cause for concern.
Okay.
And so that's kind of where I'm going here.
I
just
think
want to make
also
sure
in
there's
here,
no conflicts.
They have in here too that if you did take something that was put under conservation and you had paid the loan back or paid the funds back, and you did something else with that land, you have to replace it with the equal value or more of conservation land. That's in the bill also. So you're locked into making sure the amount of conservation land's there.
So, Senator, let me ask one more question.
That's
if
okay.
you yield. So you're convinced and assuring us that this could not be used for any private purpose for personal gain?
Other than your normal conservation easements and those kind of things, on private property, private lands, you can get conservation easements and stuff on there. So,
thank you. Thank you.
Yes, sir.
Chair recognizes Senator from the 41st for a question.
Senator Yield.
Yes, sir, I do.
Senator, I was just curious, applaud the effort here. Do you know what kind of monies have been spent in the past on this effort? What kind of funding has been implemented in the past?
I'm going to be honest with you, I don't, but I'm going to get that number. I actually thought about that early this morning, about 6 o'clock, drinking coffee, reading the bill again. And I got to thinking about that, and I'll get those numbers and all and get those to you.
And when you do that, could you also include private funding? Because when this was first raised, it was a mechanism for private funding to be gotten outside of government donations, et cetera. And
Right.
I'm curious if that's been a success, as well as if you could possibly at some further point let us know what funding in the future they're going to be asking for, or your expectations are.
Okay.
I know it's tough economic times, but I'm curious what you think the posture of this will be as far as funding in the future.
I'll be more than happy to do that, and I'll get that information to you. I wish I had gotten it before I came down here today, but it just hit me this morning, and haven't had that time to be able to get it. But I'll get that to you the next day or two. Thank you. Yes. And this is a bill that Georgia Conservancy has been involved in drafting this bill, and they're big supporters of this, changing this, the old land conservation program over to this new land conservation. They're probably one of the main drivers behind this bill.
Chair recognizes Senator 34th for a question.
Thank you, Mr. President. Will the senator yield?
Yes, ma'am, I will.
Senator, I apologize first and foremost
Okay.
because I heard you mention checkoff, and I didn't get the in-depth part of that. Can you expound on the checkoff?
I'll be more than happy to. There in the original land conservation program, there's a income tax checkoff on the income tax form that you can donate funds to the Land Conservation Trust Fund, and that's going to get added back on in the House.
Will the senator yield further?
Yes, ma'am.
We're talking state income tax.
That is correct.
Okay.
It's your state income tax.
Okay,
Some
so-
people want to check off and donate a little money to the conservation fund.
Senator, will you yield?
Yes, ma'am.
On the state checkoff, you're saying they're going to add the checkoff to the state income tax portion so that a taxpayer in Georgia can just clearly check it off, and those funds would then go to this funding source.
Right, any amount of it could. You could put a check off and do $100 or $200 or whatever amount of that money could go to this.
Thank you, Senator. Would you yield again?
Yes, ma'am.
Senator, with that checkoff, it's not on this one right now, but you're saying that's something that's to be added?
That is correct. It was in the old program, and the reason I didn't add it, I would have added it, but I was told that the House wanted to add it in committee over there, and I'm fine with that. And if they don't, then we'll add it when it comes back.
Senator, will you yield again?
Yes, ma'am.
Same subject matter.
Yes, ma'am.
What I'm trying to find out, however, is that item today is not on that return. Is that correct?
That is correct. It would not be listed as for this new program, but if we add it to the bill over in the House committee, then it'll be on there.
One last question, Senator.
That's okay.
It is my understanding to add language to the state's income tax, there's a fiscal note requirement. Are you aware of that?
No, but I actually, let me go back and say this. It really is on the income tax form now because the old program is what exists. Okay? So it actually is on your form right now. If we put it back in here, they just change the name of it. That's all they do. It's already in existence. But it won't be called Land Conservation Trust Fund. It'll be the Georgia, it'll be probably the Georgia Legacy Trust Fund. They'll just change the name of it on your form. But right now, it still exists because that is the current law.
And thank you for your answer, but I am curious, even with the change, if there's a cost associated with that change, and if so, is there a fiscal note? That was my question.
There
That's
really, to be honest with you, there wouldn't be a cost because the only thing you do is changing the name. It already exists. The program exists. Everything exists. You don't really, when they print new forms, they'll just print it with a new name versus the old name. But it all exists. All the infrastructure's there already.
And finally, my statement is,
Okay.
when I was attempting to do the same thing, I was told any change, the word any,
Okay.
does require a fiscal note because the change does cost. And that's the reason for my questioning it.
Right.
Because even though it may be an item today, if we're going to make a change, it's my understanding, based on historical,
Okay.
that there is a cost.
I will check on that. I'll write myself a note when I get down, and I'll check on that and follow up with you, though.
Thank you, Senator.
Yes, ma'am. Thank you.
Chair recognizes Senator 28 for a question.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
Senator, in lines 207 through 212, there are minimum percentages established of how the funds will be dispersed.
There is a percent breakdown. I didn't take it out. I've been talking to the House about that. I prefer not to have percent breakdowns because I think the committee that runs this program, the council, the Legacy Council, needs to be deciding how the money is broken up and spent, because you don't know the cost of everything and the size of the project. So I did not take it out of the bill, but I'm in discussions about having those numbers taken out.
Okay, well, thank you, Senator. I share those same concerns with you. And one of the ones I think is most, could be most difficult for the state in the future is that 1/4 of all funds are currently set aside for the acquisition of property.
Right.
That makes the state a perpetual buyer of property, which I don't think is necessarily a good thing.
It can be, but it's all inside this land conservation program.
Right.
And we've already got that now. We've got that now. We've had it for years.
Right.
And this is just changing it over. But I do agree with you. I don't like the percents in there because it binds you, and you don't really know what your costs are going to be doing in all the different programs.
Okay. Thank you, Senator.
Thank you.
I appreciate it.
No further questions, Senator.
All right. Thank you very much. I appreciate it if you'd vote for this, and we will move ahead to the House if we can send it on to them. Thank you.
Questions on the adoption of the committee substitute. Is there objection? Chairs none. And committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Grant report of committee. Which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 2. And this bill, MC Rex constitutional majority, is therefore passed. Secretary will read Senate Bill 243.
Senate Bill 243 by Senator Bethel of the 54th and others. A bill to be entitled an act to amend Chapter 2A of Title 20 of the OCGA relating to student scholarship organizations so as to change certain provisions relating to definitions and for other purposes. The Senate Committee on Education and Youth recommends that this bill do pass by substitute. The Senate Education and Youth Committee offers the following substitute to Senate Bill 243. A bill to be entitled an act to amend Chapter 2A of Title 20 of the OCGA relating to student scholarship organizations so as to change certain provisions relating to definitions and for other purposes. Amendment 1. Senator Bethel of the 54th and others offer the following amendment. Amend the Senate Education and Youth Committee substitute to Senate Bill 243 by striking lines 14 through 21 and inserting in lieu thereof the following. Eligible student means a student who is a Georgia resident who immediately prior to receiving a scholarship or tuition grant under Code Section 20-2A-2 and enrolling in a qualified school or program and for other purposes. Senate, Amendment 2, Senator Albers of the 56th and others offer the following amendment to Senate Bill 243. Strike lines 67 through 77 and renumber accordingly. Strike lines 119 through 124 and renumber accordingly. Through with the order, Mr. President.
Chair recognizes the distinguished senator from the 54th to present the bill.
Thank you, Mr. President. Members of the Senate, privileged to present to you Senate Bill 243, a continuation of Georgia's leadership in the area of school choice and transparency and accountability. This is an administration bill. The bill, if I'll walk you through it sequentially, Section 1 addresses an attendance requirement component that was intended originally in 2008 when this was passed the General Assembly for students to be opting out of schools where they're not succeeding, thus the true school choice arrangement. You have Amendment 1 on your desks, which is an amendment to this section. This is supported by myself and the administration. This clarifies that the attendance requirement would have 3 basic exceptions. The first would be that an individual who is zoned in a low-performing school would not be required to attend a low-performing school for 6 weeks before participating or being awarded a scholarship. The second is an individual who's a victim of violence at school would again not be compelled to stay for 6 weeks in that school. And the third is that if a parent or parents inform the school in writing that they do not wish their child to participate in classroom instruction on the basis of a religious belief, they would also be exempted from the attendance requirement. Turning into Section 2, this is an escalation from where we currently stand in terms of the amount of dollars that must be reserved for scholarships. We see that most of the leading institutions, SSOs in Georgia already participating in this program are meeting this threshold, but we want to ensure that these credit dollars that are being allocated are being maximized in terms of the amount of scholarships awarded. The bottom half of page 2, lines 38 through 62, primarily deal with situations where a multi-year scholarship award has been made, but a student were to leave school. It returns that money, restores it either to the SSO for more scholarship, or returns it to the SSO for more scholarship awards for more students. Turning on to page 3, on the transparency front, section 1.1 starts on line 67. This is going to require our student scholarship organizations to consider the financial means of any scholarship recipient in designating how they award their scholarships. The bottom half of that page is used for audit functions and what to do when an independent CPA audit returns a deficiency and how that's reported on the department's website related to SSOs. In Section 3, again, also from a transparency standpoint, we are asking on an aggregate basis for SSOs to disclose the average household income of households where a scholarship recipient resides. Importantly, in adding that as a disclosed provision, we are no longer requiring SSOs to disclose the list of donors, including the dollar value of each donation. We don't think that's an appropriate thing to be disclosed publicly, that donors' personal information and participation should be kept private. In Section 4, clarifying that S corporations have unique tax responsibilities in Georgia. The original intent was for corporate entities to be able to maximize contribution to SSOs. This increases a member in an S corporation's ability to make a contribution to an SSO. And the final substantive provision is on page 6, line 175 through 180. It's an accountability function. Most of our SSOs in Georgia do a great job of filling out or fulfilling the mission of the Student Scholarship Organization. This clarifies sort of two things. One, that the current law is you cannot get a scholarship for your dependent. In other words, you can't make the credit be linked to your child or any member of your household. This clarifies that it cannot be done for anybody else. You can't do a swap where I'll take care of your child, you take care of my child sort of deal. It has to be an arm's length transaction. Those are the substantive provisions, Mr. President. I can address Amendment 2 now, or I can come back, and I'll certainly yield for questions.
Let's take a couple of questions. Senator from 33rd, you wish to be recognized for a question? You are recognized this time.
Thank you, Mr. President. Senator Yield.
I yield.
Mr. Leader, let me ask you, did you just say that within this bill that you're listing as one of the requirements or questions asked of these folks, or to receive a scholarship, there would be financial means?
No, sir. Means testing is not a provision of the Act currently, and it will not be in the future. What we will ask is the SSOs release on a public basis the aggregate of the average household, annual adjusted gross income of the households of recipients. That is to say, from a transparency standpoint, the public will be able to see the aggregate average of the household incomes of those recipients.
But is further you?
Yes, sir.
But that isn't true with the Hope Scholarship Program, is it?
The Hope Scholarship is a universal program. So it's a different program.
Further yield?
I yield.
But that is true. It's not apparent, or it's not possible in the Hope Scholarship Program. I know it's a different scholarship program, but it's not possible with what we passed earlier this morning to be able to, in the aggregate, let the public know the same.
If the senator so speaks, I mean, it's a different program. This is a program that is funded by tax credits from taxpayers. The Hope Scholarship is funded by lottery sales. It's a different funding mechanism.
But further yield, is
Yes.
it not true that I agree with you there, except for the fact that most lottery proceeds, say 70% of them, come from Georgia taxpayers, but wouldn't we say that we're treating the two programs, and I agree they're different programs, but we've got two different ways of letting the public have some transparency here.
Senator, I would disagree. I respect the senator's opinion, and I would accept that that's how you would interpret it. I do not personally believe the Hope Scholarship is the same sort of program as the SSOs. Student Scholarship Organization's function is to allow for school choice. The Hope Scholarship is not to allow for school choice. It is to allow for folks to get in higher education funded by the state. It's not a choice of moving to one school or to another or getting out of a failing school. I think those are two different functions.
Thank you, Senator. I would agree we've kind of made them both the school choice.
Senator from the 42nd, are you wishing to ask a question, 42nd, or are you wishing to be recognized? Speak. Senator from the 36th, do you wish to be recognized? You are recognized this time.
This is Senator Yield.
I yield.
In terms of your support for this Amendment 1 that you spoke of, isn't it true that the impact of that added language, particularly lines 16, 17, and 18, would allow a family who does not participate in public schools, this does not attend public school, to simply submit a letter saying that they don't wish their child to participate in classroom instruction and doesn't require them to be enrolled there?
That's correct.
So someone who has their child in a private school now could submit a letter to the public school in their district that they don't want their child to be subject to the instruction there because of their religious beliefs, and they would be eligible.
Yes.
Doesn't that run contrary to what the stated intentions were, that we were children that were in public school? Which
the current state of affairs, Senator, the 2008 legislation required enrollment.
That's right.
it came to the state's attention that it was not an uncommon practice, although not practiced by the best in the business, the folks who are doing this the way it should be, for students to enroll but never show up. They would just enroll and not show up on the first day. This allows the public school, number one, the assurance is that for the majority of students, they are going to enroll and attend and have the opportunity, but it also allows them the transparency of knowing whether to expect somebody, so they don't hire staff expecting a certain level of students, and then those folks who enroll don't show up. They've already given an annual contract to a teacher and the related staff. Now they'll have the ability of knowing who they can expect.
If you'll further yield.
I yield.
Isn't it true that this is just another workaround to allow families who are going to send their kids to private school to get public monies? To get the eligibility for this to be having public tax dollars going to private schools for private education.
Well, I would disagree with the senator's characterization on two fronts. One, there are no tax dollars. These are contributions from individuals that they are allowed to take a credit for them on their income tax, subject to availability under the cap. On the second way I would disagree with that is the requirement is affirmative in nature, and these are exceptions. The exceptions are people who are willing to state in writing that they have a personal religious objection to the instruction of the public school, or in writing that their child was physically mistreated and harmed at a Georgia public school, or in writing that they are going to a low-performing or failing school in Georgia. Otherwise, the requirement is to enroll and attend.
Well, isn't it true that there have been startling revelations and videotapes of supporters of this effort telling people how to circumvent the law, and that everybody knew that we were going to be circumventing the law, and a lot of very shady goings on with this so-called scholarship program?
Senator, I would say that in my district, the folks I know associated with this have conducted themselves admirably. I think that those who are leading this effort in Georgia have conducted themselves admirably. I have heard tell of the sorts of stories that you describe, but I would not consider them to be widespread. On that front, I would turn your attention to lines 172 through 180 of the committee's substitute, which addresses some of those very concerns that have been raised, and it prohibits what we would consider to be the most egregious, at least alleged, actions that are going on out there, such that nobody may designate a recipient of a scholarship as a condition of having made a contribution, whether it be their dependent or otherwise. And
a final line of questioning, if you'll yield.
I yield.
I believe that the original bill that set this program up had a $50 million cap on it, or it was soon, the year after it was passed, it was lifted, it put up to $50 million. And I call that it's really a tax expenditure, is it not? Because it means that those funds won't be flowing into our revenue for the state.
Senator, the answer to your question, I guess in order, is that yes, there is a $50 million cap, which was then adjusted by a CPI, Consumer Price Index escalator, and I think now it's around 53 million and some figure after that. I don't have the number in front of me. I apologize for that. I have heard folks characterize it as a functional tax expenditure. The courts have disagreed, and this is not an expenditure of tax dollars. Certainly the allocation of funds for this program and the allowance of credits reduces funds into the Treasury. That's inarguable.
That's right.
But it is not an allocation of funds. It is not an affirmative expenditure by the state, and pretty much all the courts that have addressed the issue have agreed.
I had one further question, but I will yield in the interest of time, and
thank you,
appreciate
Senator.
your indulgence.
Thank you.
Chair recognizes Senator from the 40th for a question.
Senator Yield.
I yield.
Senator, isn't it true that this bill had a lot of work done on it? We had a lot of input for the various student scholarship organizations, both over the weekend and also in testimony. And furthermore, all the testimony that we heard in the committee meeting, including people that had in the past written scathing editorials on this particular program, thought that this particular bill was a great step in the right direction?
Senator, you are correct that in the Education and Youth Committee, and I appreciate the work of the chair from the 37th, we put a lot of work in prior to committee meeting, and all of the testimony was in favor, and it ran the spectrum of the education community.
Okay. We further yield?
I yield.
Senator, I'm going to present an amendment to your Amendment 1 and bring it down there, because I am very concerned. I understand the first two portions of Amendment 1, but if we start giving exceptions for religious beliefs, I think we've opened the things up to headscarves. I think we opened it up to yarmulkes. I think we've opened up to whole various situations that I think that's a mistake. I do not think that there's a valid reason to do this in order for a person to get a scholarship. And so I just want to let you know that that's coming.
Thank you, Senator.
Senator from 33rd, you're wishing to speak now, right? There are no further questions, Senator.
Thank you, Mr. Senator. Thank you, Mr. President. I look forward to coming back to address the amendments, and I yield the will.
Chair recognizes the senator from, I tell you what, let's do. Let's go ahead, have both amendments, or we have another amendment. Chair recognizes Senator from the 42nd. Speak to the bill.
Thank you, Mr. President. Colleagues, I intend to be brief. I wanted to commend the senator from the 54th for his able presentation of the bill. I think this bill is an example of bipartisan concern about this student scholarship operation that we currently have. As you may recall, on the very first day of the session, or one of the first, I came and talked about the level of fraud that had been reported in this program, and expressed concern and worked with numerous people to address some of the issues. And as the senator from the 40th just mentioned, numerous people have worked on this bill, and it is a step in the right direction. Does it do everything that I think needs to be done? No. Does it do enough to consider it a step in the right direction? Absolutely. And for that, I just wanted to acknowledge the bipartisan spirit of the bill and say thank you, and celebrate this as maybe the first time I've done that. Thank you very much.
There are no questions.
Thank you. I'll yield the will.
Chair recognizes Senator from 33rd for speak to the bill.
Thank you, Mr. President, ladies and gentlemen of the Senate. I guess this won't be the first time that I've been critical of a bill, but I will say this. I think this thing started several years ago. I think that they used the term the year 2008. I don't think these student scholarship organizations existed as they do now before then. And the reason for forming those things was actually an effort to be able to allow children or parents of children to utilize tax money to go to private schools. Well, we've had the Special Needs Scholarship Organization, which has expanded, even though we were told it would not. And then we've got the Student Scholarship Organizations. Now, what it does is it uses tax credits to fund this thing, and it indeed does mean fewer funds for public education and the funds that undergird public education. There's just no way around that. So we are, in a different way, losing public funds to undergird education and allowing the opting out of public schools. Now, we're not all against opting out of some public schools. When a school is failing continuously and and that's the case, we have often said, in fact, Education 2000 on, that you should be able to opt out of that public school. But it tends to lend itself from public to private at the cost of the public, because you get fewer, even though the taxpayer he's receiving a benefit to give to another organization. It's not really the taxpayer that's doing the deed as much as we're allowing that subtraction from the funding of public schools. So it's just a case where I think we're headed towards, and I'm not saying this is wrong if you think it isn't. If you're for vouchers, and I use that word because I think that's where we're headed, and if you're for vouchers, I can't argue with the fact that you feel that's the way to fund education or use tax dollars. But if you're not, and you're in favor of improving public education where all the warts may exist, then that would be more my philosophy, but I can't say that yours is wrong per se. But I do want to know what we're doing here, and that's what I feel like we're doing. I think we're reducing the amount of funds available for public education and students to improve public education. So that's my read on it. I don't know that I'd have any questions. I'm not for it, sir, if that's what you're asking, Senator. You know, I'm surprised you'd ever have a problem finding out where I'm at. Thank you. I yield.
No questions. The chair recognizes amendments 1 and 2 have been read. Go ahead and read Amendment 1A.
Amendment 1A. Senator Miller of the 40th offers the following amendment to Amendment 1 to the Senate substitute to 243. Delete the comma on line 14 and insert or. Line 15, stop at harm. Delete the balance of line 15 and line 16 through 18. Through with the order, Mr. President.
Senator from the 54 has already spoken to Amendment 1. Amendment 2, Chair will recognize Senator from the 56 to speak to his amendment.
Thank you, Mr. President. Senators, my amendment does two things. It strikes out lines 67 to 77, and then again lines 119 to 124. I think in spirit this is a very good bill. I think it cleans up a lot of necessary areas. I want to thank all those who have worked on this bill. My friend and colleague, Senator from the 54th, I think did a very good job explaining it. Let me explain my amendment and why I am looking to strike these lines. Lines 67 to 77 are brand new. This was never in this law, which has been on the books for, I believe, 5 years now. Never before did we ever say that we're going to award these scholarships and they shall consider financial needs. This is brand new language, which is basically a form of means testing. That was not the intent. This was for those who are underserved. This bill corrects the things we want to correct. This is really an unnecessary addition. And from those in my caucus and my party, we believe in giving people the options. We believe in school choice. We do not believe in adding extra components for means testing. This accomplishes not what the bill was intended to do. It's extra that can be removed and still preserve the integrity of the bill. We don't need to capture that data as well and then report it back out, even when it's on an aggregate basis. In fact, I think the senator from the 32nd earlier gave us a bill that we voted on and passed to address similar concerns in respect to the Hope Scholarship. That's all my amendment does, and with that, I'll yield to questions.
Senator, you do have some questions. The chair recognizes Senator from the 42nd for a question.
Thank you, Mr. President. Will Senator yield?
Yes, Senator.
Senator, you're aware, are you not, that this particular program provides a tax credit to these charities that is different from almost any other charity that we allow tax deductions for. Isn't that right?
I am familiar with this program, Senator.
And is that what it does?
This does provide a tax credit. That is correct.
And that tax credit has a purpose. Isn't that right?
I will further yield, and yes, I believe the tax credit does have a purpose.
Will the senator yield?
Yes.
Well, what in your view is the purpose of using this tax credit for this specialized charity? Is it have anything to do with providing choice for people who otherwise wouldn't have a choice, or is it just to provide choice for anybody?
This is to help those who are underserved, period. It never before, and why this is new language that never existed before, added a component that shall consider financial needs. This is totally new language to a bill that did not exist prior to its being entered in.
Will the senator yield for a final question?
Yes, Senator.
Why would we give special dispensation to charities that do things for people who don't need it? And why would considering need undermine any possible purpose?
Well, Senator, I would look at it the same way I would the Hope Scholarship, which is we give those dollars from the lottery fund in order to help our students to move forward and get a college education. I see these being very similar.
Will you yield for one follow-up on the Hope Scholarship?
Are you sure this is the final question, Senator?
Well, if you
I would gladly yield to you for one final question.
Thank you for your indulgence. Is it not true that the Hope Scholarship is not funded with a single dollar of tax money, and that this is funded in a very special and unique, beneficial way with tax dollars, and that it's a very, very different program that has nothing in common with the Hope Scholarship?
Actually, Senator, I think what I mentioned was it was funded by the lottery, which is the same place we fund pre-kindergarten programs, which are not mean tested as well.
Chair recognizes Senator from the 36. Chair recognizes Senator from 36.
Thank you, Mr. President. Does the senator yield?
Yes, Senator.
In reference to your comment a moment ago in the well, you said this was a program designed for students, underserved students. Should never have any means testing thing. It's designed for underserved students. What is your definition of underserved students?
When the educational needs that they're in are not meeting what that child requires in order to have the best education possible.
But isn't it true that the language of the bill says nothing about that? That's an interpretation that you've chosen to put on of your own making. That's not appear anywhere in the bill, does it?
I do not believe it. Probably everything then would be into our interpretation, Senator.
Well, isn't it true that I was a member of the House where this bill originated when it was first passed into law, and that this bill was sold to the General Assembly as a bill to help children whose families would not be able to have a private school option without this scholarship?
Now, Senator, I wasn't in the House when you were there at the time, but I'm sure that we would have had language in this bill, or it would have been amended over the years, had we had wanted to add a means testing component to this. This is brand new language that did not exist until it was brought on the floor and through committee.
Further yield.
Yes, Senator.
Isn't it true that this does not mandate anything about means testing? It just simply has language that the student's financial needs should be considered. And wouldn't that be a more appropriate use when we're expending tax credits, i.e. dollars that are due and owed to the state of Georgia? When we're expending those kinds of tax credits, isn't it true that we should be doing it for a worthy cause rather than simply underwriting wealthy people's school tuition for their children? Is that what we would, is there a public need for doing that would cause
Senator,
us to do this tax credit expenditure?
Senator, I believe that any time that we can help incent people to give more options and choice to any student, to give them a better education, is the right answer, because we have schools for one reason and one reason only. It's to educate children. And some schools are better than others for those children, and we ought to leave that decision to the parent and to the child to decide that together of what's best for them. And if this mechanism helps more children, then we've done something right today.
For the yield.
Yes, Senator.
Isn't it true that expending Georgia tax credits, which translate into Georgia dollars that don't go into our public schools, don't go into the budget of the state, that we should be very carefully considering how that's to be spent and not throw the barn door open, and that this language is appropriate to address that?
No, Senator, is not appropriate, and we have addressed those in several places in this bill to make sure we cleaned up the areas that were concerned.
Thank you.
If there are no further questions, I'll yield the bill.
Senator from the 33rd, did you have a question or you have a parliamentary inquiry? No further. Senator from the 54th, you're excused, Senator. No further questions. Chair recognizes Senator from the 33rd. What purpose you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Is it not true, for a clarification, while I was in the well and don't particularly like the general law and don't like the income tax disparity transparency, I misspoke in that after being counseled, this is an improvement over the current law, and I do find it addresses needs-based, and that I misstated that to my colleagues, and I wanted to say that without having to take your time.
I think you're right. You did misspeak, and I'm glad you admitted to your fault, and you're going to vote for the bill. Chair recognizes Senator from the 54th. Senator from, did you wish to speak, Senator? To your amendment? Chair's going to recognize Senator from the 40th to speak to his amendment. That's Amendment 1A, and then we'll have the Senator from the 54 close the debate.
Thank you, Mr. President. Might as well tick a few people off here. First of all, I was there when this bill was originally passed, and there was a lot of discussion about low-income children, so on and so forth. I remember it. We did not means test. The way this language is in the bill now, it's not a means test, but it says consider. And when I say consider, if you have two children, similar circumstances, et cetera, when it comes down to the one with the lower income, I'd probably give the lower income child a scholarship. Furthermore, if you talk to the SSOs, the largest one, goal, the average income of their scholarship recipients, family income, about $30,000. I think most of us would consider that low income. But I also don't believe in means testing, so I think we came up with a good balance. We seemed to keep everybody happy during the testimony when the gentleman from the 54th presented the bill. And that doesn't happen very often because there's been some severe criticisms of this program. So I saw the amendment today that the gentleman 54th has agreed to on behalf of the governor. And my amendment, what it does, basically does a punctuation thing on line 14. The lines that concern me are lines 15 to 18. Or whose parent or parents inform the public school in writing that they do not wish for their child to participate in classroom instructions or exercises that conflict with their religious beliefs. Folks, I could run a truck through that loophole. What is a conflict with a religious belief? I don't believe my children should be watching television, so that means they can't watch anything on screens when they go to schools? I don't see the reason for that portion of this amendment. I understand the part about bullying. I understand about the thing about failing schools. But if we go down this road where we start mixing religious beliefs on whether or not you go to a certain public school, not a private school, not where you're getting a tax credit. If I want to send my child to private school and I sent one to it, I made that decision. But a public school, if we let religious beliefs be the determination for me to get a tax credit, good luck, folks. This thing is going to just mushroom. It wasn't the intent. It goes back to low performing. Don't let that kind of loophole go through. It just is not good policy on our part. I yield the well, Mr. President.
Thanks, sir. Chair recognizes Senator from the 54th to close the debate.
Thank you, Mr. President. I will try to address these amendments and some of the comments that were made as quickly as possible. First, I and the administration of the state of Georgia support Amendment Number 1. This provides reasonable, common sense exceptions to the attendance requirements that honor and respect school choice. I quickly want to correct my friend from the 40th who said this is about whether you get a tax credit, whether you claim a religious exemption. It is not. This is the provision about whether you're eligible for the scholarship, not the tax credit. Tax credit is a contribution made at arm's length and cannot be designated for an individual regardless of their religious preferences or beliefs. This is about whether a family who in writing tells the state of Georgia that the instruction in classroom violates their religious tenets ought to be able to be eligible for a scholarship. And the answer is yes. Amendment number 1A, accordingly, we will oppose and the administration will oppose. Amendment number 2. Congressional campaigns and flyers and mailers notwithstanding, this is not a means-tested provision. The governor of the state and I oppose amendment number 2. We are talking about school choice, not tax loopholes or tax benefits for individuals. The programs are funded by people who believe in school choice, who believe in scholarships for people who are trapped in failing schools. That's how the program was pitched. If you have the means to access the private school system independently, it's not wrong for the state of Georgia, in lieu of your tax dollars being delivered to the state, to ask, would you please consider giving it to these kids who are in our worst schools, who are struggling the most? That's not unreasonable, and it's not a means test. I ask that you would vote down 1A, vote down 2, adopt Amendment 1, and pass this bill so that we'll have more transparency in this very important school choice program in Georgia. Thank you, Mr. President. I yield the well.
The senator has yielded the well. Senator from the 40th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that the senator is right? I did misspeak, excuse me. It was about the scholarship I was speaking, not the tax credit. He is absolutely right. I misspoke. I meant about the scholarship being tied for religious purposes. So he is correct. And I apologize for my misstatement, but I do not apologize for my remarks or for putting religious beliefs in for scholarship programs. Thank you.
I know you have great passion for this issue.
And I do support the bill, by the way.
I know you do. Senator from the 56th, what purpose do you rise?
Parliamentary inquiry, Mr.
State
President.
your inquiry.
Isn't it true that, unlike some of my friends, I am not running for Congress?
Senator, I can't confirm that.
Thank you, Senator. Well, thank you, Mr. President. We'll see you on the campaign trail. Mr. President, further inquiry?
State your inquiry.
Isn't it true Senator from 54th is a good friend of mine, but in and himself he mentioned that he would ask people about their means in order to address who would get a scholarship, and that in itself is a means test?
I don't think anyone disagrees that there's a philosophical difference upon this issue relative to means testing, and there's those that obviously feel very strong that this was designed specifically to help the underprivileged and those that are economically challenged, and I know that they have great passion for that issue, and so do I. Senator from the 41st.
Parliamentary inquiry.
State your inquiry.
Is it not positive today that on a nonpartisan way, the governor's floor leader and the minority leader can agree that number 2 is a bad amendment, and also in a nonpartisan way that the senator in 40th and I can have join hands and support 1A as a positive amendment? Thank you.
I love it when the Senate comes together in such a beautiful way, and the senator from the 33rd's on board. And
Mr. President, isn't it a good lesson? Is it not a good lesson for all the freshmen here today to find out how to be on both sides within one day on an issue?
No. Typically, the rule of the Senate is whatever the senator from the 33rd does, if you do the opposite, you'll be right every time. No, I'm teasing. Chair recognizes senator from the 9th.
Thank you, Mr. President. I'd move the previous question.
Well, senator from the 9th is ready to get down to business, which I think we're all ready to. Okay, the question now is on floor amendment 1A. All those in favor, rise, stand, and be counted. If you are in favor of 1A, rise, stand, and be counted. One A. Reverse. On Amendment 1A, the yeas are 11, the nays are 30, and Amendment 1A has been defeated. Now the question is on Amendment number 1, authored by the senator from the 54th, the author of the legislation. All those in favor will vote. I'm sorry. Is there objection? Is there objection on Amendment 1? Without objection, Amendment number 1 is adopted. Now the question is on Amendment number 2. Is there objection? There is objection. All those in favor of Amendment 2, rise, stand, and be counted. If you're in favor of Amendment number 2, rise, stand, and be counted. Reverse. On Amendment number 2, the yeas are 8, the nays are 41, and Amendment number 2 has lost. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree on the report of committee which favor pass the bill? Chair hears none. Report of committee is agreed to. Shall the main question be now put, or are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0, and this bill, AMC Rex constitutional majority, is therefore adopted. Very proud of the Senate. Secretary will read Senate Bill 225.
Senate Bill 225 by Senator Stone of the 23rd and others. A bill to be entitled an act to amend Article 3 of Chapter 6 of Title 17 of the OCGA relating to proceedings for forfeiture of bonds or recognizances so as to relieve a surety from liability under certain circumstances and for other purposes. The Senate Committee on Judiciary and Non-Civil recommends that this bill do pass by substitute. The Senate Judiciary and Non-Civil Committee offers the following substitute to Senate Bill 225. A bill to be entitled an act to amend Article 3 of Chapter 6 of Title 17 of the OCGA relating to proceedings for forfeiture of bonds or recognizances and for other purposes. Amendment 1. Senator Stone of the 23rd and others offer the following amendment to Senate Bill 225. Amend the Senate Judiciary and Non-Civil Committee substitute to Senate Bill 225 by inserting after the first semicolon on line 3 the following: to change certain provisions relating to remission of forfeiture by deleting code section on line 8 by revising lines 14 and 15 as follows. Principal on the bond was prevented from attending court due to a mental or physical disability and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 23rd to present the bill.
Thank you, Mr. President. Senators, SB 225 deals with certain conditions surrounding bond forfeitures, that is criminal bonds that are put up by sureties to ensure appearance of a defendant in court. It seeks to strike a fair balance and foster cooperation and teamwork in bringing the defendant back once a non-appearance has occurred and there's a forfeiture. First, let me go through the sections, including the amendment, which was the result of some last-minute negotiations between the law enforcement community and the bonding industry. First of all is a recognition that if a defendant is an involuntary inpatient treatment and so can't appear, there is no forfeiture. Secondly, if a defendant fails to appear, that law enforcement will place a detainer if he is later found with the sheriff or in custody in another jurisdiction. Now, what it does with the detainer is shorten the period from 15 days to 10 days to ensure that a expedited detainer is placed so that he won't be released by whoever has him in custody. Changes that from 15 days to 10 days, excluding weekends, so effectively gives a 2-week period to put that detainer on, and if it's requested by the bondsman, the surety, and it's not placed on, the detainer that is, then the bondsman is released from forfeiture or from a forfeiture occurring. Second, the next change deals with once there's been a forfeiture, if the defendant later shows up and appears within a specified period of time. In the first 120 days, that appearance will entitle a partial refund of all but 5%. That's the current law. The only change is that there's no evidentiary requirement to be shown as to how the defendant was brought back within that 120 days. We've restored from the original bill later returns of the defendant after the 120 days, but within 2 years, to require that there be a showing by the bondsman of substantial contribution in procuring that return of the defendant to the court. And the last major change is that deals with the situation where the defendant is located by the bondsman in another state within the United States. In that situation, if the bonding company offers to pay the cost of extradition and return, and law enforcement decides for whatever reason that they do not want to pursue extradition, then there would again be a partial return of all but 5% of the bond that has been previously forfeited.
Senator, is there anything else on the bill that you think is pertinent to the Senate?
Well, let me think. No, I think the President has accurately assessed that this may be too much information, but I would urge your adoption of both the amendment and the bill. Thank you very much.
Thank you,
yield the
Senator.
well if there are no questions.
There are no questions. There were about to be a lynching if you didn't get out of the well. Is there objection to amendment number 1 authored by the senator from the 23rd? Without objection, amendment number 1 is adopted. The question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree and report to committee which fail pass the bill. Chairs none. Report to committee is agreed to. Shall the main question be now put? Or are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. On the passage of SB 225, the yeas are 51, the nays are 2, and this bill having received the constitutional majority is therefore passed. Secretary will read Senate Bill 226.
Senate Bill 226 by Senator Gooch of the 51st and others. A bill to be entitled an act to amend Chapter 16 of Title 45 of the OCGA relating to coroners so as to change certain provisions relating to investigation fees and for other purposes. The Senate Committee on State and Local Governmental Operations recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Distinguished Transportation Committee Chairman, the Senator from the 51st, to present the bill.
Thank you, Mr. President. I will be short. This bill simply clarifies two inconsistencies in state law dealing with coroner's compensation. It does not increase the fees. I would ask for your considerable consideration, and I yield the well for questions.
There are no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the bill? Is there objection? Agree in the report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Questions on the pass the bill. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. On the pass of the bill, the yeas are 51, the nays are 0, and this bill, MC, Rex constitutional majority is therefore passed. Secretary will read Senate Bill 234.
Senate Bill 234 by Senator Jones of the 25th and others. A bill to be entitled an act to amend Code Section 33-23-12 of the OCGA relating to limited licenses so as to provide for the comprehensive revision of provisions and for other purposes. The Senate Committee on Insurance and Labor recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Senator from the 25th present. Whoa, ladies and gentlemen, let me make sure I understand this bill. Senator from the 25th, the freshman senator from Buds County. Come on up here.
Thank you, Mr. President. I rise today to introduce Senate Bill 234, which authorizes the insurance commissioner to issue limited license for travel insurance producers. This basically authorizes the insurance commissioner to issue an individual and business entity a limited lines travel insurance producer license, which allows the producer to sell, solicit, and negotiate travel insurance. This is endorsed by the National Association of Insurance for Commissioners, the National Conference of Legislation, and the American Society of Travel Agents. 4 states have passed legislation that is similar to this, and we have 20 other states that are pending legislation for this. Will allow travel agents to provide a service to their potential customers and not have to be burdened with the regulations of licensing and fees and everything that goes along with being a licensed insurance agent. So, and I would ask for your consideration today, and if there's no questions, Mr. President, I will yield the well.
Well, it's been endorsed, it seems like, by a lot of folks, but it hadn't been endorsed by the Senate yet.
Yes, sir, that's right.
And it's pretty obvious by the number of individuals that have questions pertaining to what you are trying to do to our beloved insurance industry. Chair recognizes Senator from the 42nd who has great passion over this issue for a question.
Will the Senator yield for a series of questions?
Yes, sir.
Isn't it true that you and I share an office suite and a secretary at the Senate down here?
That is correct.
And isn't it true that I'm holding in my hand a press release that says that Senator Burt Jones has passed a piece of legislation about the insurance, an important piece of legislation? Is it not true that that was prepared this morning?
Senator, I have not seen that literature. I've not read that literature. I understand through the grapevine that it is out there, but I have not read that literature.
Senator, don't you think you should have a little more respect for your colleagues and their ability to vote on a bill before you take the well that you would present you would draft up a press release saying it had passed? Strikes me as a bit presumptuous. Would you agree?
It was my understanding that it was so well written that there's no way it could have came from me, and it probably had to be my sweet mate from the 42nd, I believe.
Yeah. Smart fellow. Senator, you have 2 more questions.
Yes, sir.
Is it not true that you went to Woodward?
Yes, sir. That's correct. Woodward Academy.
Woodward Academy, and is it not true that you now represent a district that has some areas that could be considered country?
Could be considered what? I'm sorry.
Country.
Country.
Define country for this senator.
That's my question.
Yeah, I live in Butts County, so.
And how does this bill have anything to do with being country?
This bill, well, it has a great deal to deal with. You know, down in Butts County, this has more to do with citizens of Georgia as opposed to the people in my district. Because I'm from the Lake District, and we don't have to travel very far to get good scenery with the likes of Lake Oconee and Sinclair and Lake Jackson. But that's all.
This doesn't say anything at all about mama or trains, right?
No. I can tell you that does not define country.
No.
All right. Well, there's some others that might want to define it for you. Senator, Chair recognizes Senator from the 22nd.
Thank you, Mr. President. Does the Senator yield?
Yes, sir.
Senator, is it not true that suite that you're in, that I'm the predecessor and I was there before you got there?
Yes, sir. I believe you're correct on that.
And is it further not true that, like the senator from the 42nd, I gave you guidance as a yellow jacket not to have that press release prepared?
Like I said, I have not read any such press release.
As a senator, further you.
Yes, sir.
Senator, is it not true that we had a conversation about country and boots on yesterday?
Country and boots? Yes, sir. I think I was complimenting my favorite senator from the 6 on his cowboy boots.
As a senator further yield.
Yes, sir.
Senator, while we were talking about those boots, is it also not true that you were asked whether or not you were a patriot?
That is correct. That is correct.
And what was your response?
If I could be half the patriot that the senator from the 22nd was, I'll be a good patriot.
Yes, sir. All right, Chair recognizes another great patriot, the senator from the 56th.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
Now, Senator, you said there 4 other states have already done this. What states are those?
California, Florida, Minnesota, and Kentucky.
So you believe just because those 4 states had done that, that the state of Georgia should do that? Senator, let me ask you a further question. I mean, if they were all going to jump off a bridge, should we follow them?
Well, it just depends on how good the bridge, what was on the other side.
Will you yield for one final question?
Yes, sir.
Can you confirm rumors that you're running for Congress?
Do what now? I'm sorry?
Can you confirm rumors you may be running for Congress?
Congress, no. I think I'll pass on that. I'm having a hard enough time in the well here.
Oh, that was pretty good. Senator from the 3rd is recognized from the coastal region.
Thank you, Mr. President. Does the senator yield?
Yes, sir.
Senator, before you undertook this process of drafting legislation, did you receive any special training or instruction to help you with writing a law?
That's a good question.
No, I think that's what we have the good people over at legal counsel for, Senator. And
well, let me ask you a couple of questions, a couple of more questions.
Yes, sir.
Do you believe that a bill should be clear and specific and leave nothing to implication?
Well, it depends on who's reading it. You know, some of us have a harder time of following some of this legislation that we pass, but we should try to make it as clear as possible.
Well, you would at least agree that terms should be well defined in a bill, correct?
So the senator speaks.
Well, I've looked at your bill, and your bill has 127 lines of bill, and only 26 of those define any terms. So I think we should look at a couple of your terms to see if they're well defined. Is that okay with you, Senator?
It's fine with me, Senator.
If you look at line 17, it says that a limited licensee means a person or entity authorized to sell certain coverages. Now, what coverages are we authorizing them to sell? I don't see the word
under
certain.
Under this, it's just travel insurance.
But it doesn't say travel. It says certain. That could open it up to anything, correct?
A limited lines. This legislation specifically talks about travel insurance, but they do. And you are correct in saying that they just say limited lines in this bill, but it is specifically just for travel insurance.
Just travel insurance. Thank you, Senator.
Chair recognizes Senator from the 18th for question, the very distinguished majority whip that has a lot of background in travel.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
Is it not true that after reading your first attempt at crafting legislation, the whip is having grave concerns about your appointment as deputy whip?
So the senator speaks.
Well, the senator will further yield. We'll explore that a little bit. Senator, we are all very much full of admiration for the fact that on the 30th day of your first legislative session, according to line 2 of your bill, you are undertaking comprehensive revision. You feel qualified after 30 days as a senator to be undertaking comprehensive revision of the insurance code?
Well, as you know, as a deputy whip, we get great counseling from our majority whip, and so to undertake such legislation, I believe, could only be accredited to the fine leadership that we have here in this body.
You're smarter than I thought you were, Senator. Will the senator further yield?
Yes, sir.
There's a word that you use a lot in your comprehensive revision, and it's a word that I have a little bit of some question marks about it. It's the word notwithstanding. Could you please define the word notwithstanding for this body?
Repeat that again, I'm sorry.
And after you define notwithstanding, could you tell us, are you using it as a preposition, adverb, or conjunction?
Like I said, they looked for the person with probably the lowest IQ to carry this bill, and they found him with me, and so I can't speak intelligently on that.
All right, so if the senator will further yield, so we're not quite sure why we use the word notwithstanding so many times in your bill. Let me ask one further question, if you will yield. On line 21, and I'll go back to line 70, you say the limited lines travel insurance producer shall also certify that the travel retailer registered complies with 18 U.S.C. Section 1033. Could you give us a brief summary of 18 U.S.C. Section 1033, because I fear that most of us have no clue what that
It has to make sure that he has no criminal background.
No criminal background.
Mm-hmm.
I think the senator's right about
All
that.
right.
Last
Okay.
time I checked.
I'll accept that for now. All right, Senator, because of the lateness of the hour, I'm not going to keep you much longer before I vote against your bill. But if you will further yield, when you take your seat, do you plan to vote for your bill or just sit there as you have on other occasions?
I think I'll vote for it.
Good job, Senator. Thank you.
All right, last question will be from the senator from the 50th. Okay.
Senator, will you yield?
Yes, sir.
I'm just a little concerned about your inability to define country. So I want to help you just a little bit. Now, I'm going to give you some choices. I'm going to make it easier. Do you live on a dirt road, a hard road, or a gated hard road?
I live on a hard road, ungated, close to a dirt road.
Thank you.
Hold on. Senator from the 53rd, I can't leave the rules chairman out. You may never get another bill on the floor if I do. Don't.
Thank you, Mr. President. Senator Yield.
Yes, sir.
I've got some tough questions here for you.
This is that IQ test you was talking about.
Senator, your bill, now I ask this question a lot during these, especially when a freshman has a bill, and I'm so disappointed. There's no reference here to moral turpitude. Can you please tell me why you would have a bill of this extension here that has no indication of your morality presence here or what you have planned in the future that could be questionable when it comes to moral turpitude?
You know, this bill does deal with people in general,
and most bills do.
And anytime people are involved, there's always the potential for moral turpitude to occur.
Well, Senator Yield, say yes.
Yes, sir.
Would you please give us a definition to moral turpitude?
You know, it's something my mama taught me a long time ago, and I just
good.
know she'd rather me keep it to myself.
I'd yield the well if I was you, Senator.
Yes, sir. I'll yield the well, Mr. President. There's no further questions. Thank you.
Buzz County's finest, ladies and gentlemen. All right. Just because we clap for you doesn't mean we got to vote for your bill. Does any other senator wish to speak for or against the bill? Is the objection agreed upon the committee which failed to pass the bill? Chairs none. The committee is agreed to. Shall the main question be now put? Or are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. All right, this one's struggling to get up there. Help him, help him, help him, help him, help him. Thank you. 55 to no, 0. On the passage of the bill. Congratulations, Senator. Chair recognizes, Secretary will read Senate Bill 231.
Senate Bill 231 by Senator Loudermilk of the 14th and others. A bill to be entitled an act to amend Article 10 of Chapter 21 of Title 15 of the OCGA relating to Georgia Drivers Education Commission so as to extend the sunset provisions for the additional sums collected on fines and for other purposes. The Senate Committee on Judiciary and Non-Civil recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Senator from the 14th. Present the bill.
Thank you, Mr. President. Because it is such a long day, I'll be very brief with this. Senate Bill 231 simply extends the sunset on Joshua's Law, which was set to expire on the end of June this year. It just extends that out for until 2018. If there's no questions, I'll yield the well.
Actually, there are a couple of questions. Chair recognizes Senator from the 41st.
Senator yield.
I do.
Senator, the Joshua Law, remind me, it was to encourage training of people in schools for driver's education?
It was named in honor of a young man from my district who was killed in an accident, and it was adding on these additional fees to traffic fines to help pay for driver's education in public schools.
Thank you. And do you know in the last 2 years how much money was raised and how much was actually given to this purpose?
I don't have those figures in front of me. We have looked into those. I'm also aware that not all that money has been used for driver's training.
Senator, if you'll further yield for a series of questions, would it surprise you that a very small amount of the monies raised in these fees ever went to the actual purpose designated under this legislation, original legislation?
No, Senator, it doesn't. As you know, the situation we've been in the budget crisis, and also that we have no way of earmarking the funds to go directly to that program as we do any other program that's not covered in the Constitution of the state of Georgia. However, it is up to this body and the body across the hall in coordination with the executive branch to determine how much money goes into that. And this bill does not change that.
Senator, further yield.
I will.
But you can't tell us on an annual basis how much these surcharges on fines actually comes into the general fund?
I don't have those numbers in front of me. I think it's somewhere in the realm of about $10 million.
Do you have any idea what amount of fines? There are other add-ons. Can you give us a list of what other add-ons are also on similar type fines?
Well, I know that there's several out there. This bill doesn't include those, but there are those dealing with disposal of tires and others. But again, this bill simply focuses on the Joshua's Law program.
Thank you, Senator. And would you state the impact on children in Georgia if they do have driver's education? Is it not true that that does, whether it's through the schools or privately, it does enhance their safety and does promote longer living by young people to have driver's education?
Well, I can state that that was the purpose of this program. I believe that the research and studies that have been done do support that idea. And again, that was the entire purpose of the Joshua's Law when it was passed several years ago when I was in the House.
Thank you. Senator, knowing that I support driver's education for children, is it not true that it would be important to us to be able to fund programs like Medicaid and other issues in a way that the public expects, and that when we have legislation that's supposed to dedicate funds to worthy purposes, those funds should really go to the purpose that we promote, inform, and educate the public is our intent when we pass the legislation. Is that not right?
I do not disagree with you on that, but again, I'll reemphasize that there is a level of control through this body and the one across the hall through the appropriations process as it exists now.
Thank you.
Chair recognizes Senator 36.
Thank you, Mr. President. Senator Yield.
I will.
Senator, first I'd like to applaud the fact that you brought this to the General Assembly some years back and passed this law on behalf of constituents who had had a tragic loss of their own son, Joshua. And you're to be commended for your leadership on that. Does it concern you that we're getting in a situation with the fees not being allocated for the purposes that are stated in the statutory language, that we're walking on some pretty thin ice?
Well, Senator, just one correction. This wasn't my bill a few years ago. It was from the previous senator from the 52nd when I was in the House. But, and again, as I answered the question before, that's been a concern since the first day I took the oath of office almost 10 years ago. That's always going to be a concern, but this bill doesn't address that. This simply extends the program out 5 more years, and again, through the appropriations process, there is a level of control of that in both houses of the General Assembly.
Are you aware, Senator, if you yield further for a series of questions, that this fee has generated almost $75 million since we put this in law?
I'm sure that you're correct on that.
And further, that this esteemed legislature and this administration and the one prior to it, only $7 million has been appropriated for teen driver education.
I'm sure the senator knows the facts that she speaks of.
And isn't it true that the public can get a very jaded view of what we do and what role government plays when we put something in as a fee like this, and then in fact expend those dollars that we collect on everything but what we said this fee was for?
Again, let me emphasize that this bill simply extends the program. It doesn't address whether the money has gone there in the past or will go there in the future. I understand the concern that you had, and that has been addressed in several different ways. But according to the Constitution of the state of Georgia, we do not have the ability to earmark these funds. That'll be this left in the appropriation process. But yes, I am an advocate that if we pass a piece of legislation that funds are to go to a particular program, that we should make every effort that we can within this body, within the body across the hall, to fund those. And I'm sure the senator would agree with me that we've been in extenuating circumstances the last few years in making budget decisions based on the limited revenues that we have, and there's many programs that this state has that we must fund. And so, but I would reemphasize, this bill doesn't address those. It's simply extending the program as it exists.
Thank you for your response on that. And would you further agree with me that we send the wrong message to the public? And when we ask them to vote for another tax or another fee, such as the T-Splost, and we get a resounding no back from the public, that the public's attitude could very well be rooted, and I've heard from my constituents that it is, in viewing the Georgia government as not doing what they said they were going to do with this fee for teenage driver education, with the fee that we collect for hazardous waste, with the fee that we collect for old discarded tires, and that we are doing ourselves and the public a disservice when we continue the practice of not expending the fee where we say we're going to expend it.
I'm sure the senator knows what she speaks.
Thank you, Senator.
Chair recognizes Senator from 38 for a question. 38.
Will the senator yield?
I will.
In the questions that were just asked by the senator from 36, I'm a little confused as to why we are extending, asking for a 5-year extension when the majority of the funds are not going to the program that we earmarked it to go to. So I need to understand why we're trying to extend something that's not doing what we wanted it to do to begin with.
Well, first of all, Senator, we have no ability of earmarking these funds. That is not This is not an area that is included in our state constitution. We have no ability to earmark them except for those exceptions that are in our state constitution. So the program, the revenue that we bring in, it's part of our process that we have here, is that through our appropriations process, we make a determination on the available funds and the programs that are out there and priorities that are in place. And one of the greatest priorities that's been out of this body and the one across the hall has been education. And we've been struggling in the past few years to provide the adequate funding for that. So again, this bill doesn't address the application of the funds directly. It simply extends those funds for another 5 years. And I would encourage you to participate actively in the appropriations process to ensure that these go in those directions. Now, whether they will in the future or not, I can't answer that question. But I can guarantee you this, that if we don't pass this bill, there will be no funds going to driver education as part of this program, because it will come to an end.
Will the senator further yield?
I'll yield for one more.
Okay. Thank you. I appreciate that. What effect has this legislation had on teenage automobile accidents?
I'm sorry, could you repeat that?
What effect has this particular piece of legislation had on teenage accidents? That's why we're doing driver's ed, right?
That is correct. As far as the exact impact, that's something that you can't really qualify, because how do you know if an accident doesn't happen as a result of something that we've provided the education to a driver? So it's a question that I don't know that there is an ability to directly answer, because how do you qualify something that doesn't happen? So I would say that the program has had a positive effect. Its intention was to have a great effect. But I can tell you that if we don't extend it, it will have no effect at all.
Thank you.
Thank you.
Chair recognizes Senator from the 4th for a question.
I will, sir.
Sir, just quickly, as we spoke about the 13 budget and the 14 budget the other day on the floor, wasn't it kind of vividly pointed out during the presentation that fees and any other dollars that the state takes in this particular year went to fill the hole in Medicaid, that had we not had those fees and had those funds to go into that hole, that would have either caused other departments that are vital to the operation of the state to be cut even more than the 1 to 3% they were already cut, or presented the legislature with an issue that we might have had to consider a tax increase. So the fact that fees are being used for the operation of state government doesn't mean they aren't being used, isn't it true, for things that are incidental. They're being used for very important things that everybody in this body supports, namely Medicaid at this point in time. Is that not true, sir?
That is absolutely true, and I think that's one of the aspects of our form of government here in the state of Georgia, that we do have the flexibility to prioritize the revenues that we have. And, Mr. President, if there's no other questions.
Senator from the 35th, I think, is the last one to have a question.
Thank you, Mr. President.
Thank you, Mr. President. Will the gentleman yield?
I will.
Isn't it true that for the past 2 years, Joshua's fund has not been funded at all and taken any applications?
I think you've heard from the questions that have been asked that it hasn't been funded to the level that many would like to see that being funded since its inception. But I can also make the argument that a lot of other programs that some would like to see funded can make the argument that they haven't been funded as well. If you go across the state, many schools are saying they're not receiving the funding that they expect. Almost every special interest group out there is going to make the argument that they didn't receive the funding that they would like or they would expect.
Will the gentleman further yield?
I'll yield.
Well, those other organizations or groups that you mentioned don't have money exclusively in the legislation for them to receive, and Joshua's law has not accepted any applications in 2 years, and the money, millions of dollars, have gone to that fund over the past 2 years. In fact, isn't it true that 22 out of the 64 applications that were put in, only 22 were awarded, and the others were not even awarded prior to 2 years ago?
I'm sure the senator knows what she speaks. Again, the whole idea behind the program, which I think was the intention of the program, was was pure. It was for a good reason. And, you know, we're in an unfortunate circumstance with the economy and the position we are right now that we have to prioritize funding as it comes in and to what areas it goes. And I'm sure the senator is very passionate about driver's training and would like to see more funds go into that training. And as I spoke earlier, if you are opposed to the driver's training, then you can vote against this bill and a guarantee that no money goes into it. Go ahead.
Will you further yield?
Yes, I will.
Isn't it true that if we vote against this, this will not mean that we don't support driver's ed? In fact, if I vote against it, I did, in fact, put it in legislation in the 90s and in the 2001. And the one in 2001 could not be funded, but it said that any school that could find the funds for it. So that would not be the case if we don't vote against it. It'll be because this bill is not necessary if it's not doing what it is there for.
Well, you can. Every senator's got the ability to vote whichever way that they choose on this bill, and I just recommend that you do this as you see fit. But we all know when bills go through these chambers, that unless it is an item that is specified in the state constitution, regardless of what it says on the paper, that any monies that come in will go to the general fund that are subject to the appropriations process of this body and the one across the hall. When this bill was passed originally, I believe in 2006, that was known as part of that process, that because it is not in the Constitution, it could not be earmarked. It would always be subject to the appropriations process, as with any revenue stream that comes into the state. Okay.
And finally, so you are saying that this is just another tax to go into the general fund then, if we so choose?
No, ma'am, this is not a tax. This is a fine that is imposed upon those who are breaking the laws of this state, just as any other fine would be. So I would not categorize that as a tax. Taxes are those things that we involuntarily pay. You have the choice of whether you break the traffic laws of the state or not. So this will be categorized as a fine.
Thank you.
Mr. President, I think we've hit the gist of this matter. I appreciate your favorable consideration, and I will yield the well.
No question. Chair recognizes Senator from the 4th. Has amendment number 1 been read? Read amendment number 1.
Amendment number 1. Senator Carter, the 42nd, and others offer the following amendment. Amend Senate Bill 231 by inserting between lines 19 and 20 the following. The fee amount provided for this code section shall be subject to revision if it is not fully appropriated for use by the Georgia Drivers Education Commission as intended by this article and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 42nd. Speak to his amendment. Please give the senator your attention.
Thank you, Mr. President. Colleagues, I bring this amendment given the discussion that we've had about the way in which we appropriate and collect fees, taxes, fines, and other items. I think it's important that we be honest with our constituents and with the taxpayers of our state and with everyone who's impacted by our state budget about where our money comes from and what we do with it. I have great respect, as I've mentioned many times, for the senator from the 4th. I have great respect for the senator from the 14th, and I support the bill. But my support for the bill is exactly what led me to bring this amendment, because I believe that we should invest in driver's education and we should carry out the intent of this legislation. But I believe the only way to do that is by being honest about where the money goes. Right now in our state, we do not have a healthy or honest debate about our state revenues. We stood here this morning and made a lot of political speeches about balanced budgets, about living within our means, and yet we don't talk about our state revenues with any sort of transparency most of the time. In fact, earlier this year, we passed, I know we have had to fill a hole in Medicaid. We've discussed that. Earlier this year, we passed a bed tax on hospitals that we had to go through 2 disguises in order to pass. There's a huge amount of rhetoric that comes out of this body on all sides about being fiscally conservative and fiscally responsible, but we still have to also be honest about how we spend our money. This fee and fine is another disguise, like the bed tax that we call it a fee, like a variety of other things to disguise the fact that we need revenues, and we're going to get them however we can. Now, I believe, and what this amendment does is very simple. In that context, it says that if we appropriate an amount that's less than 80% of the amount collected. In other words, we can take 20% of this fee and do whatever we want with it. But if we go below 80%, we're going to reduce the fee. Simple. It's living within our means. It's being honest about where the money comes from and where the money goes. And I think that we would all be better off if we can be clear about where we stand as a state, if we can be honest with our constituents about where the money comes from and where it goes. We all know that we have a fiscally conservative government. We collect fewer taxes per capita than any other state but 2, is what I'm told. We spend less than any other state but 2. We have succeeded in shrinking the size of our government, but we still have to be honest about how we operate. I think this bill opens that up. I think it puts our money where our mouth is with the rhetoric of living within our means. And if there's no questions, Mr. President, I'll yield the well and I'd ask for adoption of Amendment 1.
No questions, sir.
Thank you.
Is there objection to Amendment number 1? Without objection, Amendment number 1 is adopted. Does any other senator wish to speak for or against the bill? Is there objection agreeing the Report of Committee which fail to pass the bill? Chairs none. Report of Committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is order. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill vote aye. Those opposed no. Secretary will unlock the machine. On the pass of the bill, the yeas are 51, the nays are 1. This bill, MC Rex constitutional majority, is therefore passed. Secretary will read Senate Bill 113.
Senate Bill 113 by Senator Jones of the 10th and others. A bill to be entitled an act to amend Code Section 9-11-4 of the OCGA relating to process so as to change provisions relating to personal service of a summons on a corporation and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass by substitute. The Senate Judiciary Committee offers the following substitute to Senate Bill 113. A bill to be entitled an act to amend Code Section 9-11-4 of the OCGA relating to process so as to change provisions relating to personal service of a summons and for other purposes. Through with the order, Mr. President.
Chair recognizes the distinguished senator from the 10th.
Thank you, Mr. President and members of this body. First, let me just say how much I appreciate the senator from the 29th, the chairman of the Judiciary Committee, who never, ever gave up on Senate Bill 113. Certainly without his support, I know this bill wouldn't be on the floor today. And again, I just want to extend my thanks and appreciation to the senator from the 29th. Senate Bill 113 is a process service bill for corporations. It simply removes the ability to serve a secretary or a cashier. That language is contained on the first page on line 15. On the second page, it gives a definition for what is considered a managing agent. I am very appreciative of the support this bill has received from the Georgia Chamber, from the National Federation of Independent Businesses, even from the trial lawyers, because I'm not a lawyer, but I have slept at a few Holiday Inns, and the other Bankers Association, other groups that have gotten behind this legislation. And I would strongly encourage each of you to support a very, very business-friendly piece of legislation that will aid a lot of large as well as small businesses. And if there's no questions, Mr. President, I'll yield the well.
There are no questions, Senator.
Thank you.
The question is on the adoption of the committee substitute. Is there objection? Without objection. Was there objection? Oh, I didn't think so. Questions on the adoption of the committee substitute. Is there objection? Chair is none. Committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Go ahead and report to committee which favor pass the bill. Chair is none. Report to committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill vote aye. Those opposed no. Secretary will unlock the machine. On the pass of the bill, the yeas are 49 and the nays are 0. And this bill, having received requisite constitutional majority, is therefore passed. Secretary will read Senate Bill 236.
Senate Bill 236 by Senator Jones of the 25th and others. A bill to be entitled an act to amend Title 33 of the OCGA relating to insurance so as to require insurers issuing accident and sickness policies in this state to indicate on their premium statement to consumers the amount of the premium increase and for other purposes. The Senate Committee on Insurance and Labor recommends that this bill do pass. Amendment number 1, Senator Jackson II offers the following, and others, offers the following amendment to Senate Bill 236. Amend Senate Bill 236 by deleting lines 2 through 4 and inserting the following. Provide that insurers issuing accident and sickness policies in this state may indicate on their premium statements to consumers the amount of the premium increase or decrease and for other purposes. Amendment number 2, Senator Hill of the 32nd and others offer the following amendment. Amend Senate Bill 236 by striking the quotation mark at the end of line 24 and inserting after line 24 the following. The Commissioner of Community Health shall also provide notice to each person covered under the health insurance plans established pursuant to Article 1 of Chapter 18 of Title 45 and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 25th present the bill.
Thank you, Mr. President. This arises today for Senate Bill 236, which is a department bill by the Insurance Commissioner that requires health insurance premiums. It will require health insurance premium companies to provide us with exactly what the Affordable Care Act is going to do to both new and individual, new and group policies and renewals as well. Having been in the insurance business for 10 years now, I can understand the concern with the Commissioner's office, because one of the first questions that you're asked is, why are my insurance premiums going up? And this right here with the legislation that's coming down the pipeline that's going to be implemented here in the very near future, it is good for us to be transparent with the consumers of Georgia, and so exactly what this legislation that's coming down is going to do to our insurance premiums. And I'd love for your consideration of this bill, and if there's no questions, I yield the well.
Senator from the 33rd, you wish to speak. Senator from the 2nd, you wish to speak. Question. Speak. Question. Speak. Question.
On the floor.
No. Senator from the 38th, you wish to ask a question or speak. Question. You're recognized at this time.
Will the gentleman...
Yes, ma'am.
This bill is putting, it looks to me like, what, on line 14, we are saying that you, what are you saying with line 14? Maybe I should ask that. Line 14 and line 23. What specifically is this bill doing?
It's basically saying whatever insurance premiums are attributed to the Affordable Care Act, you know, the line item be stated for you. This is pretty common in the property casualty business. They obviously show you line by line what liability costs, what property costs, and in health insurance they can provide you with the formula that is that causes the increases. And since this is such a broad scope, you know, it just basically is asking our insurance companies to show exactly what the percentage of the increase will be.
Will the gentleman further yield?
Yes, ma'am.
Isn't it true that the Affordable Care Act is based off a Republican idea from the Heritage Foundation and a Republican governor in Massachusetts?
I couldn't hear you. I'm sorry.
Is it not true that the Affordable Care Act is based from the Heritage Foundation and a Republican governor in Massachusetts?
If the senator so speaks.
Will the gentleman further yield?
Yes.
Is it not true that this law uses a competitive marketplace, not a public system, but a private system to bring down prices?
That the Affordable Care Act is to bring down prices? Well, if it does do that, then I think it's fine that we disclose to the citizens of exactly what it does to the insurance premiums. If it brings it up or brings it down. That's all we're asking out of the insurance company.
Will the gentleman further yield?
Yes.
Isn't it true that premiums can increase by failing to completely implement the Affordable Care Act due to health status of new enrollees?
You know, there's a number of reasons why insurance premiums can go up or go down, and the insurance companies have those formulas in place, and they have them calculated already.
Thank you, Senator.
Chair recognizes Senator from 22nd for a question.
Thank you, Mr. President. Does Senator yield?
Yes.
Senator, in reference to Section 1, line 14, I think I understand the spirit of what you're trying to accomplish. My question is this: is it not true that in the last 3 years, the state health benefits insurance premiums have increased?
I'm not on the state plan, so if the senator so says.
Does Senator further yield?
Yes.
Is it not true that the PPAC does not really go into effect until 2014?
That's correct. I believe you're right.
Okay. Thank you, sir.
Chair recognizes Senator from the 33rd for a question. You wish to speak? Chair recognizes Senator from the 39th for a question.
Will the Senator yield?
Yes, sir.
Are you aware that the best consensus research is that for every person without health insurance, there's a cost to all other people with health insurance of $1,300 per person with health insurance?
If the senator so speaks.
If that is indeed the case, if the senator will further yield, do you
Yes.
think that's a salient fact that ought to be included along with the information that your bill would require?
Well, what my bill is just offering here is to show exactly what our cost is going to, whether it be positive or negative, but show exactly what the Affordable Care Act is going to do to insurance premiums here in Georgia.
All right. Thank you, sir.
I yield the well.
Senator has yielded the well. Chair recognizes Senator from the 2nd to speak to the bill.
Thank you, Mr. President. Ladies and gents, today I rise to talk about transparency. True enough that I believe, much as the senator from the 25th, I believe that government should be transparent. But I also believe in the Affordable Health Care Act. I believe this Affordable Health Care Act is good for America. I believe the Affordable Health Care Act is good for Georgia. I believe the Affordable Health Care Act is good for every American in our country. But as I look at Senate Bill 236, I would also like to indulge you to talk about a bias. I offer a simple amendment, and it removes the bias from this bill by adding a simple statement, increase or decrease. Because we know that with the Affordable Health Care Act, premiums may increase, but they also may decrease. So I ask you to look at this Amendment 1. It simply says that the insurance companies will let the consumer know whether their premiums will increase or will also like to know if premiums will decrease, because we need to know the positive of the Affordable Health Care Act. And I think premiums will decrease, and it's our right and our obligation to know when it will decrease. This amendment shows true transparency. And if you believe in Georgia, you believe in transparency. Mr. President, if there are no questions, I yield the will and urge everyone to support Amendment 1.
Senator from the 48th has a question.
Yes, sir.
Will Senator yield for a question?
Yes, sir.
Isn't it true that although the amendment does add some additional information that could be disclosed, that by striking the word shall and inserting the word may, you've made transparency optional for the insurance industry?
Sir, I believe in true transparency. The insurance companies will be obligated and willing to let its members know.
Will the Senator yield for another question?
Yes, sir.
But on line 7 of your bill, you make this transparency completely optional to the insurance company by striking shall and inserting the word may.
If the gentleman would prefer the word shall, if you make that as a friendly amendment 1B, it will be accepted, sir.
I think your proposal stands on its own.
If there are no questions,
Senator from the 30, Senator from 36, you wish to be recognized for a question.
Yes.
Thank you, Mr. President. Does Senator yield? Senator, on your amendment on line 11, I noticed that it calls for the insurer to publish on its website the methodology utilized in making such determination. Isn't that really essential to have this bill mean anything? Is that consumers will be able to look at the methodology and trust the methodology because it's transparent, as opposed to just putting something on a bill with no background as to how those numbers were arrived at?
Senator, you're absolutely correct. Without this amendment, insurance companies can use any methodology they choose, and some may be inaccurate. So we need to know that every insurance company has some consistency, and this will show consistency.
Thank you, Senator, for
Thank
bringing
you.
this amendment. I think it improves the measure before us.
Thank you.
Chair recognizes Senator from the 54th for a question.
Thank you, Mr. President. Will Senator yield?
Yes, sir.
Senator, isn't it true that 332922 of the OCGA deals with premium increase notices?
Yes, the Senator so states.
Senator, isn't it also true that your amendment would add to the cost of health care by requiring a new mailing, which is a premium decrease notice, which is heretofore not a part of Georgia law?
It shows true transparency, sir.
Would the Senator yield?
I do.
That transparency would come with a new cost to Georgia providers, would it not?
I don't think that cost to the new Georgia provider will be minimal, if any at all.
Thank you, Mr. President. Thank
Senator
you,
from the 26th, you wish to ask a question or speak? Senator from the 26th going to speak. There are no further questions for the Senator from the 2nd.
Mr. President, I yield the will.
Thank you, Senator. Chair recognizes the Senator from the 33rd to speak to the bill.
Thank you, Mr. President, ladies and gentlemen of the Senate. Let me disclose immediately when I get up that insurance companies don't like me. And they're right. They shouldn't. Because they've been caught several times. 12 years ago, insurance companies took over this capital. They did away with all the mandated coverage for children. They tried to do away with every single mandated provision under our state health insurance plan. Now let me tell you something else they do, because I believe the insurance companies are wholly and fully in favor of this bill. I think it's the Insurance Companies Protection Act. You hadn't heard anybody against it, have you, from the insurance companies? Each year, or every 2 years, this is based on the average 6 or 7 years ago, so forgive me if it's way off, but I wouldn't think it's down, I think it's up. There are 2,600 rate filings in Georgia. They are not available to you. You cannot get them. Now, to be fair, it was true under the insurance commissioner in the Democratic Party and every insurance commissioner in the Republican Party since. It's a bipartisan deal. The election is funded by insurance companies, by the way. The insurance commissioner ought to be appointed. Now, the current insurance commissioner is a friend of mine, but I will say this. If you can go over to the Department of Insurance and ask to see how much your insurance company, how many rate increases they filed for this year, I will tell you that I've been told no for the last, excepting this last 2 years, the last 8 years before that. We had a study committee. Only 2 of us would sign it, even with the information they found out. They're also supposed to publish in the paper how many rate filings they've had during that year and their financial condition. I see another bill somewhere around here that says they're doing away with that obligation to publish to the public their health, their stability, and the number of rate filings that they've had. Well, they're trying to do away with that publication in the publication of the county organ, of the legal organ of the county. I see that bill. I don't know whether it's come forward or not. And then we get a bill like this. No reflection on our young senator here, because I don't think he's trying to do anything but what he thinks makes sense, and I just disagree with him. I would tell you this. This federal bill that tries to insure 40 million people that is not receiving insurance coverage today, just like the senator from 39th said, for every uninsured person, the insured people get tagged about $1,300, but the insurance companies are betting on the come on the short profit end, the profit for the short time. And now we're going to write a bill that lets them decide how much of it was due to the federal bill. Who's going to decide that? Who's going to audit it? Who's going to write it? The insurance companies. Now I'm going to tell you, when you leave this building every evening on your way home, you better check and look behind you and make sure that gold's still on the dome. Because I fear, if not, it'll be on the stationery of the insurance companies of the state. That's kind of like Congress. You love your congressman and hate Congress. You love your agent. But I'm telling you that the minute we pass this requirement that they publish rate filings and that they be made available to the public, the pitter-patter of little feet all of a sudden, we passed out of the Senate 6 times, went straight across the hall and killed the bill. This is nothing more than a political attack on the president's bill, which tries to insure the uninsured, many of which are children. What's wrong with that? They'll never tell you. The insurance companies won't tell you. The long term is the savings. The short term is they're talking about profit with their companies. You know, I never understood how the former governor of Massachusetts could not explain why he instituted the very same program in Massachusetts, yet felt the federal bill was wrong. I would tell you that until insurance companies start making their rates available to all of us all the time, that I don't want to give insurance companies any more power to come up with a mathematical formula as to why they're raising rates, what the cost came from, who raised it, and for what reason. It's a closed shop. If you ever want to look at the race for insurance commissioners, go find out how many people contribute to this normal everyday citizens and how many people are affiliated with an insurance company. It's wrong and it needs to stop. So my message to you is not to give them any more power to decide how to disclose anything if they won't disclose everything to the public. I yield.
Chair recognizes the senator on the 26th. Speak to the bill.
Thank you, Mr. President, and ladies and gentlemen of the Senate. I rise because Senate Bill 236 to me is a political ploy. Why don't we, if we want to talk about insurance and transparency, why don't we talk about the Georgia Health Benefit Plan? You see, nobody wants to talk about a couple of years ago we had $785 million in the health reserve insurance. And of course, the former governor, Governor Perdue, spent the money because we were having bad times on the economy. We came up with the CMOs. We got a big increase in insurance, got a 20% increase on your copay. And then you went to the formulary and changed the medicines that people were taking just trying to live. Why don't we talk about transparency there? Why don't we talk about that United Health and all these other folks get about $800 million in rebates? And who does it go to? The corporate folks. Why is it that the money is not spread back and sent back here to help us reduce our costs? They'll tell you it does. But when you go to them, they used to have what they call, if you file or if you go to your doctor and they run the test, then they will come back and you would file with the insurance company because they wouldn't pay for a particular drug, what they call prior approval. But then they turn around, and I'm going to give you a for instance, because I can tell you about it. I've been fighting with them for the last 4 years. I take a drug called Novolog. And what Novolog does, if your blood sugar is high, you take X amount, and it reduces it, and you count calories. They were paying for it. All of a sudden, they make a deal with a drug company. They make a drug called Humalog, supposed to do the same thing that Novolog does. Guess what? Went on Humalog, the doctor had to prescribe it. A1C went up to 12. Blood sugar went out of compliance. And doctor said, it's not working for you. It's just some drugs don't work for everybody. And it just happened that this one doesn't work for you. Go back to United Healthcare, and guess what they tell me? Either you take Humalog or you die. That's basically what they told me. Said, we're not going to pay for it. So every month, I spend about $180 on one drug just to live. But where's the transparency? We're talking about state health benefit. Now, if I, as a legislator, know who to call and who to touch, what about those folks who are just regular state employees, retirees, trying to live on fixed income, and they won't change a thing, but they're making all the money? Now, if you want to talk about transparency and the Affordable Health Care Act, let's talk about the State Benefit Health Care Act. We had a good insurance program. We had one of the best in the state. Everybody wanted to be on it. We brought the lunchroom workers on. We brought the bus drivers on. But all of a sudden, our plan is nothing now. We need to go to the private market and try to see if we can't find us a good insurance program. What we ought to do is bid our insurance out again, and I guarantee you, United Healthcare and all the rest of them will get right with the prices. So we want to talk about affordable health care. Let's talk about affordable health care. Is it the Obama Act or is it affordable health care? First of all, anybody in here knows that emergency room health care costs higher than anything in the world. And the folks we are talking about insuring are those folks who have no health insurance, but when they get sick, they're in the emergency room. And the reason they're in the emergency room, because they don't know what the problem is, and they're probably on their last leg, and the emergency room is the only one. But that is the highest cost primary health care you can get. We got a doctor sitting right there. Don't you know he'd rather deal with somebody to prevent things than to have them going to the emergency room? But then those of us who have insurance, we have to pay an ante up to help take care of the cost of those who don't. Let's talk about transparency. Let's stop jumping on the other side because the other side happens to be a Democrat. That's what we're doing. We playing games, y'all. Y'all know what it is. We playing games. We won at the national level. Get over it. We won. Didn't win in Georgia, but we won up there. So, ladies and gentlemen, let's talk. When you talk about affordable health care, let's talk about affordable health care in Georgia. Let's make the insurance company do what they ought to do. These CMOs that we've got to handle our benefit plan, make them come in. Why don't we have the chairman of appropriations tell them to come in and tell us about how much money they got on rebates and where that money is going that they got on rebates, $800 million on a formulary. And then come in here and tell us why you deny prescription medicine for folks who the doctors have prescribed the medicine for. Now the insurance CMOs are becoming the doctors and they determine what's going to be paid. Now, if we want to talk about transparency, then let's talk about it. But let's include everybody. Let's don't just pick one side. Let's pick it all. Today I ask you, what you're trying to do is run with the rabbits and bay with the hounds. I yield the well, Mr. President.
Question is on the adoption of amendment. Senator, you wish to speak to amendment number 2. You are recognized to speak to amendment number 2.
Thank you, Mr. President. Senate Bill 236, Amendment number 2, is real simple. It makes the provisions of this bill apply fully to the state health benefit plan. Fully to the state health benefit plan. I think it's important that the state employees of this state, the teachers, and all the other 600,000 plus recipients also have the same information that will be provided in the private sector. You know, PACA has been in effect, the Affordable Health Care Act has been in effect for the last 2 years. Someone said it's not till 2014. That is incorrect. It's applied over the last 2 years to the state health benefit plan by providing coverage up to age 26 for dependents and non-dependents. You can be a non-dependent of your parents and still get coverage under the state health benefit plan today, because that's what's required under PACA. You also have been paying for the last 2 years preventative care measures, extended preventative care measures that are required there as well. That's all coming through the state health benefit plan. I think it's wise that we provide our state employees, our teachers who are telling us every single day, why are your health insurance costs, why are my health insurance costs increasing on an annual basis? The vast majority of that reason is because of age 26 and preventative care measures that are already mandated in current law. The provisions that we're looking for, among others, in this transparency are the requirements under PACA for minimum loss ratios for insurance companies, the provisions for preventative care, the provisions for up to age 26, the provisions to see just about everybody and provide a one-size-fits-all government-run health care plan that I believe is the wrong approach for the United States of America, in spite of it passing barely in Washington, D.C. There are solutions in the free market. Georgia's been a leader in advancing free market health care solutions. We will continue to do so, providing preventative care for our young people and older and elderly and everybody in between. providing greater access to health care, and incentivizing and encouraging individual responsibility for all recipients of health care. We need to focus on health and not sickness. Today we have a sick care program called health insurance, and I think it's wise that we turn the tables and start focusing on personal responsibility. Lastly, the Affordable Care Act comes with a huge price tag. Yes, a huge price tag that our people, our state, and our nation cannot afford to pay. With that, I commend to you the bill, and I also commend to you amendment number 2, and I ask that you support it. Thank you. Mr. President, I yield the well.
Willing to take a question?
I'll take a question.
Chair recognizes Senator on the 19th.
Will the Senator yield?
Yes, Senator, I do.
Senator, do any state employees or their dependents, are any of them covered by the Affordable Health Care Act?
They are today, and we have been the last 2 years. We've actually got almost $150 million we put in our state budget over the last 2 years to provide for preventative care and up to age 26 coverage. That was required immediately upon passage, and that's been in effect over the last 2 years.
Do you contribute our health care premiums going up?
At least 25%. The question was, are our health care premiums today and over the last 2 years attributed to that? And the answer is yes, they are. Probably over 25%. I had the number before me last year, but it's a substantial reason for the increase. Since I've been elected over the last 8 years, I think for a family of 4 or 5 or however the family coverage has gone up almost $150 a month just in the last 8 years, and it's gone up substantially in the last 2 years. The bulk of those increases, over half of those increases, have been incurred by each of us and by our teachers and other state employees because of the provisions of the Affordable Care Act that are in place today and apply today in the state of Georgia to our state employees. With that, Mr. President, I will yield the well in the second time.
You're going to yield, or are you going to take any more questions? No. He's not going to take any more questions. He has yielded the well. The question is on amendment number 1, authored by the senator from the 2nd. Is there objection? There is objection by the author. Chair recognizes senator from the 2nd. What purpose you rise? State your inquiry.
Isn't it true, sir, that this amendment shows true transparency, and without it there would be a bias in this legislation if passed?
Senator, I am confident that you have great passion in what in which you speak. The questions on amendment number 1, all of those in favor of amendment number 1, rise, stand, and be counted. Rise, stand, and be counted for amendment number 1. If you are in favor, senator from the 2nd. Amendment. Reverse. On amendment number 1, the yeas are 17, the nays are 31, and amendment number 1 has lost. Now the question is on amendment number 2. Is there objection? Objection to amendment number 2. No objection. Without objection, amendment number 2 is adopted. Does, there wasn't a substitute. Does any other senator wish speak for or against the bill? Is the objection agreed in the Report of Committee which fail passes the bill? Chair is none. Report of Committee is agreed to. Shall this bill now pass as amended? All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. Senator from the 33rd is recognized. What purpose you
Parliamentary inquiry, Mr. President.
State your inquiry.
Can you tell us how many coverages over the last 10 years children and older folks have lost in our state health care insurance plan?
Unfortunately, I couldn't answer that question for you.
Well, thank you for taking it.
On the adoption of, or the passage of the bill as amended, the ayes are 36 and the nays are 17, and SB 236 is therefore adopted. Secretary will read Senate Bill 241.
Senate Bill 241 by Senator Hill of the 6th and others. A bill to be entitled an act to amend Article 2 of Chapter 3 of Title 20 of the OCGA relating to Board of Regents and University System so as to provide for leadership and service recognition of students applying to institutions of the university system and for other purposes. The Senate Committee on Higher Education recommends that this bill do pass by substitute. The Senate Higher Education Committee offers the following substitute to Senate Bill 241. A bill to be entitled an act to amend Article 2 of Chapter 3 of Title 20 of the OCGA relating to the Board of Regents and University System so as to provide for leadership and service of recognition of students applying to the institutions of the university system and for other purposes. Through with the order, Mr. President.
Chair recognizes the senator from the 6th to present the bill.
Thank you, Mr. President. Members of the Senate, Senate Bill 241 comes from the knowledge that military service is not only good for our country, but it's also very beneficial for the individual who gets the opportunity to serve. The Georgia Leadership and Service Admissions Act basically creates a model within Georgia that already exists federally with our service academies, the way our congressional representatives appoint a member of their delegation or a member of their community for appointment to the service academies. That's what this seeks to create for us, for members of our community that seek to gain admission to ROTC programs within the state of Georgia. So that's basically it, and I would appreciate your favorable consideration, and I'm here to answer any questions.
Chair recognizes Senator in the 41st for a friendly question.
Senator, yield.
I yield. Senator,
before I vote on this, I need to know again, what is your family relationship to the senator from the 32nd?
He's a great man, but we are not related.
Thank you. I'm voting yes.
They go to the same barber. No further questions, Senator.
Okay, thank you.
Questions on the adoption of the committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed to Port Committee which failed pass the bill? Chairs none. Port Committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those no. Secretary will unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 0. This bill, MC Rex constitutional majority, is therefore adopted. Secretary will read S.R. 293. Senator from the 51st, stand by.
Senate Resolution 293 by Senator Gooch of the 51st. A resolution honoring the life of Mr. Ralph A. Pierce and dedicating a road in his memory and for other purposes. The Senate Committee on Transportation recommends that this resolution do pass by substitute. The Senate Transportation Committee offers the following substitute to Senate Resolution 293. A resolution dedicating certain portions of the state highway system and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 51st to present the resolution.
Thank you, Mr. President. This is the annual name I'm being pushed for time back there. This is the annual road naming resolution. I ask for your favorable consideration. I yield the well.
Uh-oh, Senator from the 31st has got a question now. This is probably has a physical impact, just FYI.
Does the senator yield?
Yes, sir, I will for you.
I know you're the chairman of the Transportation Committee, but you seem to have something about dead people. Is there something going on up there in the mountains that we need to know about?
Well, the older we get, the closer we get to that, I guess. But there's the theme this year has been death and taxes, right, Senator? I'll yield the well, sir.
You get a little closer to heaven the further you get up north, that's for sure. The question is on the adoption of a committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree and report a committee which fail pass the bill. Chairs none. Questions on the adoption of the resolution by substitute. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 46 and the nays are 0, and this resolution is therefore adopted. Secretary will read Senate Bill 213.
Senate Bill 213 by Senator Tolleson of the 20th and others. A bill to be entitled an act to amend Article 9 of Chapter 5 of Title 12 of the OCGA, the Flint River Drought Protection Act, so as to clarify legislative intent, to revise definitions, and for other purposes. The Senate Committee on Natural Resources and the Environment recommends that this bill do pass by substitute. The Senate Natural Resources and the Environment Committee offers the following substitute to Senate Bill 213. A bill to be entitled an act to amend Article 9 of Chapter 5 of Title 12 of the OCGA, the Flint River Drought Protection Act, so as to clarify legislative intent and for other purposes. Amendment number 1 by Senator Sims of the 12th and others. Offer the following amendment. Amend the substitute to Senate Bill 213 by striking line 103 and inserting in lieu thereof the following. Other state and federal agencies, universities, the Georgia Water Planning and Policy Center, and other appropriate entities undertake. Amendment 2, Senator Williams of the 19th and others offer the following amendment to Senate Bill 213. By adding on line 240 following Section 7, no well or borehole shall be drilled or used for the purpose of injecting surface water into any aquifer in the state of Georgia. Through with the order, Mr. President.
Chair recognizes the senator from the 20th. Present the bill. 20th, senator from the 20th.
I've had so much fun today already listening to the lies and distortions on this bill. And I know a lot of you don't really understand a lot of the water policy because you don't have to deal with it like we do all the time. Our committee deals with it. I deal with it. I was in Columbus, Georgia, helping meeting with the mayor over there and her water policy team. And I feel like my district's the whole state of Georgia because it is. And these are serious problems. Southwest Georgia has serious problems. And what we're trying to do is help them. And you got to do it incrementally. This Flint River Drought Protection Act here is basically amending the Flint River Drought Protection Act that is in place in code now. This bill understands that the economic well-being of the state of Georgia is dependent. It is dependent upon a strong and efficient agricultural industry. And there is no doubt about that. This is one of the most, well, it is the largest single industry in the state of Georgia. And it's a great industry, and we're trying to continue to make sure it can stay strong. And every part of the state is different. And you really have to understand that. Every part of this state is different. And the lower Flint region is much different than any other part of this state. And we're working real hard. The people that have been involved in this, with this bill, are agricultural people, because this is impacting agricultural water withdrawals is what it's doing. And we've had Farm Bureau involved in this, all the farm business community involved in this. We've had people off the council down in the Southwest Georgia region, the Water Council, involved in this. This is a very sensitive, delicate issue, and you can't play games with it. You can't listen to people scream in the hall about emotional things and you get upset with it and it scares you. You can't do that. The second page deals with definition, just lays out definitions. Aquifer storage and recovery is not even listed in this bill. And they've been screaming bloody murder, sending out emails and screaming aquifer storage and recovery. Well, when you find it in this bill, you call me and let me know. I mean, don't put something on an email that's a distortion of the truth. This state has not banned aquifer storage and recovery, but yet it has not said that we can use it either. There's a lot of sound science and study that has to go into that over time before we ever go down that road. Yes, we did say that we can't use it on the coast because they've got salt water intruding into the aquifers on the coast. So we have banned it on the coast, but the rest of the state is not banned. We don't know. There are 20 states out there that use aquifer storage and recovery. The state of Georgia is not one of them. We hadn't gone down that road. I can't tell you 25 years from now whether we're going to have to go down that road or not. I don't know. If you can see that far down the road and understand what you're doing today for 25 years down the road, then you are quite the rocket scientist, no doubt about it. But 20 states that use aquifer storage and recovery today. And they have no contamination problems and no problems. So I'm not telling you we're ever going to use it. I don't know whether we'll ever use it or not. We augment some flows down in the Southwest Georgia region by using whales. And the main reason behind that is to help with the Endangered Species Act. Some of these big creeks go bone dry. They go bone dry. We've got a big well down in Spring Creek region down in Southwest Georgia. And that's to augment the flow so that we can help with the Endangered Species Act. I think maybe a lot of the screaming out in the hall is they want to have endangered species problems down there so they can file lawsuits. That isn't called being a very positive person. Trying to find solutions for the problems is being a positive person. I worry about the Atlanta region. I worry about North Georgia. I worry about the coast. I worry about the West Georgia over there with Columbus and all. I go meet with these people. I go have discussions. Let's try to find solutions to problems. But I'm not going to blast out emails with lies and distortions on it. I'm not going to do it. Anyway, that's my preaching for today, but I get very disturbed when people put out stuff that's really not true. Section 3, we talk about conduct and participate in studies related to management of water resources in the Flint River Basin. We've got to participate in studies and understand the connection between the surface water and the groundwater. We've got to understand that. We've got to understand how we can be sensitive as to how we use that water so that we can maximize the potential of that water and yet not create problems for ourselves. Section 4 talks about EPD by March 1st each year. If they think we're going to have a severe drought, they have to predict it by March 1st. Well, let me tell you, you come out of winter and it hadn't rained in the wintertime, you know you're going to have a drought. That's not maybe, you're going to have a drought. Now, how bad that drought gets is another story. If you have a dry spring, you're going to have a bad drought. If you get a wet spring, we may solve some of our problems. Like this winter, we've had a lot of rain this winter, thank God. I rode all over this state in September and October, and I'm going to tell you, I have never seen this state that dry. I saw a guy bush hogging down in his pond with his tractor. That's how dry it was. The pond used to be there, but it was bone dry. I saw wetlands dried up. I saw creeks dried up with grass growing and weeds growing in them. I saw something that scared me to death. It really did. It scared me for every part of this state because we were headed for a crisis. But thank goodness we got a wet winter and rebuilt some reserves, but we still need rain through the spring and summer. We don't have to have as much rain as we were going to need, but we are going to need more water. And a crisis can reoccur. But anyway, this bill here deals with studies. Senator from the 12th and I she's supposed to have an amendment that deals with on page 4, section 5. It talks about all the different studies, and down in that region they've got a Georgia Water Planning and Policy Center in Albany, Georgia. They deal with agricultural water issues, and we want them heavily involved in the issues of how we deal with the water issues here in that southwest region. They live in that region. We want them in there, and she is supposed to, you got that? She's supposed to have that out on the desk. It's taking that water policy center, which they deal with agricultural water issues, and we want them engaged here in all these studies, because I think it'll help the farm community down there feel relieved that they've got somebody that they really trust involved in these policy discussions. But we've got to do that. Irrigation efficiency. Irrigation systems are so much more efficient than they were 20 years ago, it ain't even funny. They've come a long ways, but we still have further to go. And in this bill, it talks about efficiencies of different irrigation systems as to when they were permitted. Whether you were permitted back pre-1991 or you were permitted past 2000, getting up to an 80% efficiency for those systems. You don't think that's a lot of water? You get those systems up to 80% efficiency, and we will save a lot of water. Not only that, the Water Stewardship Act that we all passed out of this building back in, I think it's 3 years ago, it all runs together, looked at is the nation's largest conservation water bill ever passed in this country. About 3 weeks ago, I got a call from the Great Lakes region up around the border of the United States and Canada. They're having a severe drought, and they're looking at that conservation bill that we passed that's going to have a huge positive impact on this state over the next, decade as it all gets implemented over time. It will save a lot of water for this entire state. You go out and build an apartment complex today, you got to sub-meter every unit in that apartment complex. So people are going to see how much water they're using, and they're going to pay that bill separate from the rent instead of it just being included in the rent. And I think that will have a positive. You can't even go to the store, hardware store, and buy a water shower fixture or plumbing fixture that's not a water saver anymore in the state of Georgia. That's going to save a lot of water over the decades ahead. So we're moving down the right roads. This is very hard, tough work. So don't let people stir your emotions out here in the hallway, because we've got to continue being more efficient at the water we use in this state, and every region in this state is different. And we're going to continue down that road. I know that they scream about augmentation. So what they did in the email is talk about aquifer storage and recovery. Well, that's not even in the bill. So don't go writing about something that's not even in the bill. We do augment, but we're augmenting some flows down there in that region with water, with whales. And that's going to help this state. And they talk about, well, you're augmenting the flow, but we can't use the water. Well, if we augment the flow and we use the water, we're going to have a dry ditch. I mean, that's not changing water law in the state of Georgia. You got to have permits to have water withdrawals from ground and surface now. I mean, what are you saying? I mean, a permit means you've got a certain amount you can use. So is that changing water law in the state of Georgia and the riparian rights? No, it's being rational and reasonable. We got to know what we're using. This bill even talks about encouraging voluntary retirement programs of unused surface water and groundwater farm permits that aren't even used anymore. Because if they're listed, they're considered 100% used. And we negotiate with Florida, that's all considered 100% used. I bet you could go to a town like, it's grown a lot in southwest Georgia, like Moultrie, Georgia, somewhere like that, and you could probably go find a neighborhood that used to be a farm. It used to be a farm, but it's not anymore, it's a neighborhood. But I'll guarantee you it's still got listed in the permit listings out there. I bet it's still got a farm withdrawal permit on it. But we need to get rid of those, and that's what we're going to do as we classify these permits over time, as it was in the previous bill. It was in the Water Stewardship Act. But we got agriculture to come to the table and come up with that idea. We bring people to the table. People were brought to the table on this, that this impacts. And they had say into this bill. And that's how we're doing water policy in the state of Georgia. So, ladies and gentlemen, I'll be more than happy to take questions. I'm telling you that this is very difficult policy that we deal with, but it is very important to this state. Economically, this policy with water is very important to the economic environment of this state. And if we have a region as big as the Southwest Georgia region go down economically from agriculture, we will all be scratching our heads and wondering how we're going to come up with money in the budget to fund anything. So with that, Mr. President, I'll be more than happy to take questions.
You do have some questions, Senator.
All right, bring them on.
The first one is, Senator from the 42nd is recognized for a question.
Thank you, Chairman Yeo.
Yes, sir, to my friend from the 42nd.
Thank you, Senator. My question is, number one, I admire the work that has gone into this bill and agree with the vast majority of what you've said. I have questions solely with respect to what you've called augmentation. And my question is, how is augmentation and augmenting of stream flows different from the discharge permits and all the other things that we put back into the Flint River today in municipalities and other places?
Well, I'm not really sure exactly how to answer that question, but augmentation is that when we get in severe times of drought, I mean, like we did this summer and fall, that augmentation of that Spring Creek down there, which was a big creek, that augmentation of water into that by the state, augmenting that flow, keeps it from drying up. And it does help with the endangered species. And so we're trying to augment the flow when the times are that we get so dry that we really need to. Now, in good times and waters like now, we don't need to augment. If we have a decent spring and a decent summer, we won't need to augment. But let me tell you, you know what this fall looked like. If you rode around the countryside, it was bone dry.
And And we yield for a follow-up.
Yes, sir.
I guess my question is, when you say augmentation, where does the water come from?
That augmentation of that particular one was from a ground well. And we put a well in, and then we augmented the flow into that creek. You come down to a deep well, and you go down deep in the aquifer and get that water and bring it up to the surface and help augment the flow of that creek.
And may I follow up again?
Yes, sir.
Yield? Well, are you aware of any other types of augmentation other than taking it up from a well? I mean, because I'm trying to get at what that word means. And I know I'm a lawyer, and sometimes y'all fuss at me about it. But if we're going to say that the state may fund or invest in projects to augment stream flows, I think it's important for us to know what we're talking about.
That really is the only thing the state is using. And when people talk about aquifer storage and recovery, they talk about taking water during high flow periods and putting it into the aquifer and then bringing it back out during dry times. But the state doesn't do that. I'm not going to tell you we never will, but the sound science is going to have to say it's okay. And you got 20 states that do it, so I'm not going to say it's never going to happen, but I don't know when that day will be. I mean, it may be 25 years from now. I have no clue. It may never occur. And if we get better, like we're doing, better with using the resource that we have and more efficient with using the resource, we may never have to go down that road, and I hope we don't have to.
And we yield for a question about after augmentation, what happens to the water?
Yeah.
Okay. My question is, in addition to authorizing augmentation, we say that, as you pointed out, that we then restrict the use of that water outside of the normal rules of permitting, outside of all the other things that farmers and other downstream users are used to, and create a special set or special flow that's owned by the state or by somebody. How is that not a dramatic change in Georgia's water law?
It is. It really is not. But you have to think of the fundamental reason you're augmenting, okay? We're augmenting because it's so dadgum dry, the creek beds are drying up. And so we augment that flow to help with endangered species and to keep us from going bone dry. And it concerns me that people send emails about that stuff when they particularly know that if it goes bone dry, we'll have lawsuits flying from Endangered Species Act. And to me, we're trying to help solve those problems. And that's why we don't augment and then people just be able to suck the augmentation right back out of the creek, so we'd be right back to where we were. Thank you, Senator.
Chair recognizes the senator from the 40th for a question. 40th for a question.
Senator Yield?
Yes, sir.
Senator, I don't question your intent here at all. You've put a lot of work in this, and I want to follow up on the Senator 42nd's question. And if you look at lines 183 to 185.
I'm sorry, I couldn't hear that number.
Well, you look at lines 183 to 185, that's on the notification, and it's when you're doing the augmentation, and that's when it says the water provided by the project's not available for withdrawal. You're talking about the downstream people. When you do this project, based on, I think this is based upon one person's notification, the director, right?
Well, the EPD has to be the one that notifies
That's what
people.
I mean. So,
yeah.
So if he makes a determination that we need to do this is the one person from EPD, that means the people below where we're doing this, they're shut off from water.
No, you're not shut off from water. But what you're saying is that if we're going to augment, I mean, they're using water now, okay? But if we're going to augment, we can't use that extra amount that we're augmenting with because we don't want that big creek or river to go bone dry.
Okay.
Okay. It's not a matter of we don't want people to be able to use it, but the only reason that we're augmenting it is to keep us from being bone dry down there. And that's it. That's the only reason.
Can I follow?
You sure can. Yeah, I ain't got anywhere to go.
How are they going to know which water they can use and can't use? I'm just trying to figure out.
Well, you've got a certain amount of withdrawal rights that you have, okay? And everybody has permits and withdrawals. And this is above and beyond to flow into the creeks and things down there to help augment the flow. Now, they may have a groundwater withdrawal. I don't know that person that's next to that augmentation. Okay. But we just know that augmentation amount can't be used because we'd be back where we were, and there wouldn't be any use in augmenting the flow because we'd be back to drying that creek right up.
One final question, would you use?
Yes, sir.
And I want to make sure, because you've said that there's a lot of misinformation. I want to clarify something.
Right.
So when we talk about the stream flow augmentation, that's not the same thing as this aquifer storage and recovery then?
No.
No. Two totally different subjects.
Two totally different subject matter. I mean, they're so...
No, that's okay.
I know, but they're so totally different because we don't do aquifer storage and recovery in the state of Georgia. I'm not saying that 25 years from now we won't. I don't know the answer to that.
Okay.
But it's going to have to be very sound science that says that we can do aquifer storage and recovery without any problems. But as of today, we don't do that because we don't have that sound science.
Thank you very much.
Yes, you're very welcome.
Chair recognizes the senator from the 28th for a question.
Thank you, Mr. President. Will the senator yield for
yes,
a series of questions? I appreciate and understand to some degree the problems we're faced with water shortages in Georgia and all over our nation. I cover an area that the Chattahoochee River Basin is a very large part of our district. And so we're concerned how these two river basins interact. Mm-hmm. Is there anything in here that looks out for the Chattahoochee River Basin at the same time it's protecting the Flint?
This is basically dealing with the lower Flint. And this is, we've got a lower Flint, Flint River Drought Protection Act already in law, and this is amending that law and taking those steps at a time. You have to take water policy a step at a time. Very concerned about the Chattahoochee. I mean, we have great concerns about that. But this is dealing with that lower Flint, this particular issue here. And so, I mean, don't think we're not concerned about Chattahoochee, because we are.
Okay, thank you,
and all we do is deal with it 12 months out of the year.
I understand. There's great discussion in here about irrigation systems efficiencies, mm-hmm. and it kind of talks about two different irrigation systems. Can you explain how we delineate between the two?
Well, they got different types. They got some that are stationary and some that are mobile that can be moved to other places, but trying to get them efficient is a great idea. Now, I've been out to fields where they hook computers up to them, and they actually register each nozzle down that irrigation system, and then they fine-tune them and put new nozzles where nozzles have gone bad, and it's amazing the water savings that occurs. And so we've got to get more efficient, and I'll say this, agriculture has done a fabulous job in that. They really have, but you can't stop.
No, I understand.
You got to keep on going.
If you could help me with that, the legislation specifically identifies two different efficiency levels. One is 80% for irrigation systems, and the other one is 60% for what you referred to as mobile and solid set irrigation systems.
Right.
Which ones fall under the 80% category?
And
I guess that to go down the line of thinking, what is this going to cost our farmers to get them to meet these standards, and has anybody considered that?
Well, and that's why you have it. You have, if you'll look all the way down that page, that's why it's staged out. And it's not like tomorrow morning you've got to be at 80%. That's why you got so many years to get those systems to that efficient level. And we will also track this over the next 2 or 3 years, and we'll see how that's coming. And then if we need to make adjustments, we will. And this whole bill, all this water policy, you can't take water policy and pass it and assume that it's stationary. You know, it is something that we'll track, we'll follow it, and that's why we specifically wanted to take the Water Policy Center down there in Albany and use them and have them engaged in this, because they'll be able to help track this for us.
So I guess the answer to the question is it correct that we don't know what it's going to cost our farmers to come into compliance with these regulations?
No, but that's why they were involved in putting this together. Okay? And I mean, I'm sure that there are people that have a roundabout estimate to do a system. And I'm sorry, I don't have that figure for you, but I've seen it done out in fields. I've seen computer systems hooked up to them. It's pretty amazing.
Okay. And just one more question, if I may, Senator, and thank you for educating me in areas I don't know everything about, which are many, as we'll find out. But touching on what the senators from the 40 and 42nd talked about with augmentation, the current augmentation process we use is to withdraw water from the underground aquifers and pump it up into a stream and then let it go down
Right.
to the Apalachicola.
That is correct.
And go.
Now, that's not 24/7, 12 months out of the year. That's during dry times.
I understand. Okay, so that could some people rightfully consider that reverse fracking?
I guess. Hadn't thought about it that way, but we have a lot of wells in this state, and everybody seems to be doing pretty good off that well water. So, yeah.
Senator, is the Farm Bureau in support of this?
Yes, they are.
Did you?
Oh
announce
yeah,
that?
I've had discussions. Farm Bureau, Agribusiness Council, all these people, and a matter of fact, talked with Jeffrey from Farm Bureau this morning before we came into session, or was it lunchtime? I can't remember. But we had a great discussion on it. They're fully engaged in this. Their policy team is very positive and very engaged in all this water policy.
Very good.
And we include them in all this water policy.
Senator from the 13th, did you wish to, you're recognized to ask a question.
Yes, sir, Judge.
Would you comment on Section 4 about how that works in regard to if the director determines we're going to have a drought in the coming year, and then certain farmers or certain groups are requested not to irrigate certain lands, and they're paid certain amounts of money?
They are. It's kind of like an auction, an irrigation reduction auction. When you're looking at a region like that has its massive agricultural industry, okay, and when you see that you're going to have a drought, and you know coming out of winter whether we're going to have trouble or not. That's not top secret. You know from the rainfall that we've had or have not had. And so they have this to have a irrigation reduction auction. It depends on how severe the drought is as to how many acres they need to take out of irrigation production. Doesn't mean they can't plant and produce, but they won't be able to irrigate some of it. But it is a voluntary auction that people can get paid some dollars for taking that land off irrigation just for that season.
Will you yield one further
Yes,
question?
sir.
And where would that money come from?
Comes from the state. Comes from EPD. They've got a fund that deals with that, and so it does come from the state. But you're talking about critical water issues. And, this year I think we're in pretty good shape.
Thank you, sir. But
last year we were not.
No further questions, Senator.
All right, let me just tell y'all, and I know y'all been bombarded by a lot of noise, and I understand that, but understand this water policy is very touchy and difficult. And you're talking about a huge section of the state, and I would ask you to support this bill and make sure that we continue to creep down the road in this water policy to make a positive difference for all the people in the Southwest Georgia region, among other water policy that we do for the rest of the state. So I would ask you to support this bill. This is very important policy. Thank you very much.
Thank you, Senator. Senator from the 12th, you wish to be recognized to speak to amendment number 1. What amendments have not been read? 3 and 4. Amendment number 1, Senator 12.
Thank you, Mr. President. Simply, the intent of this amendment is to insert the Georgia Water Planning and Policy Center into the bill, and that will be on lines 103, right after universities. And the Water Policy Center has been a part of District 12 since the year 2000, and the intent or the Water Policy Center provides the General Assembly of Georgia and its citizens current research information and data, as well as expertise in the area of water policy. And this is the only one of its kind in the state, so we would appreciate your consideration in supporting this amendment. And the author, as you recognize, approves this amendment. So thank you, Mr. President. If there are no questions, I yield the well.
No questions, Senator.
Thank you.
Clerk will read 3 and 4, amendments 3 and 4.
Amendment 3, Senator Carter, the 42nd, offers the following amendment to the substitute to Senate Bill 213 by striking lines 174 through 201. Amendment 4, Senator Cowser, the 46th, offers the following amendment to the substitute to Senate Bill 213 by adding following line 115, studies to develop actionable baseline information related to return flows to the Flint River Basin, interbasin transfers of water, reservoir releases, and municipal and industrial water use in the Flint River Basin, and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 19th to speak to Amendment 2.
Thank you, Mr. President. I am generally for most of what is in Senate Bill 213. We do have to, because of drought conditions, we do have to place some regulation on water. And I'm not opposed to augmentation, as long as it's augmentation that we understand and that we agree that we could do. Augmentation, using a well to pump water into a stream in low flow times, while I can't say that I think that's the best augmentation, taking pristine water from the aquifer and pumping into a stream, it may be necessary. One of the best forms of augmentation, which we really ought to be promoting, is building reservoirs and capturing surface water in surface lakes and ponds, and then using that water in times of low flow. The one augmentation that I am against is because I don't think we know enough about it, is taking surface water and injecting that surface water down into the pristine aquifer. I think there's some risk there. We have not studied it here in this state. It could be in this bill, although it's not mentioned. It could be a form of augmentation. What my amendment does is just simply says you can't do that in Georgia. We already said that in the aquifer down in the southeast part of the state. This just says you can't you can't inject surface water into the aquifer, nor can you drill for those purposes. I think what we do with ag is necessary. We're requiring the farmers to use more efficient systems, and frankly, more efficient systems will save the farmer money. The irrigation systems that were designed years ago, they use a lot of water, and now you can actually measure how much moisture is in the ground and tune your systems only to put as much water as the plant needs. There's the downsizing of the orifices on the various pivot systems. Lots of folks have moved to drip irrigation. As prices of crops go up, they can use drip irrigation, which is you're actually only watering the plant and not all the ground around the plant. So I think, the bill, I think, has merit. The other amendments, use your own judgment on that, but I think we should not allow aquifer storage in the state until we know a lot more about it. Mr. President, there are no questions. I yield the well.
No questions, Senator. Chair recognizes Senator from the 42nd to speak to amendment number 3.
Thank you, Mr. President. I also commend the senator from the 20th on creating a good management bill for the lower Flint River, for the entire Flint Basin, and I appreciate all the work that he has done for that part of our state. I think that, as he mentioned, it is a complicated bill, but there's one section of the bill that, to me, is a sideshow. And that section is on augmentation. Right now, we have an experimental project, but we have no idea if it works. We have no idea how much it's going to be able to do. We don't know really anything about its ability to solve our problems. At best, we know it's a Band-Aid, and it doesn't address the fundamental problems that we have on the Flint. Now, the problem I have with this section, all my amendment does is it strikes line 174 through 201. This is a good bill, but this section is controversial. This section you have been hearing about for a reason. It's because it doesn't help and it has the potential to hurt. It also, in addition to talking about augmentation, which we can't define, we're not sure what it means, we don't know what we're allowing and what we're not allowing, we just use the word augmentation. Now, if we cut this part of the bill out, the bill becomes solid, good, strong water policy. As it stands here, this whole section on augmentation stands out, and it does two things. Number one, it codifies augmentation. They're currently doing a study in Southwest Georgia to determine whether or not it's going to have any impact at all. So we still today don't know whether augmentation is an answer. We have no idea. And there's no reason to go down this road or to pave this road if we don't think we're going to need to travel it at all. If we need it, we can come back and we can do it later. Let's get the sound management principles that the senator from the 20th has established in the rest of the bill in place, and then talk about augmentation some other day. The second thing it does that's very troubling is it creates essentially a state ownership of that flow that is augmented. We don't know. That means that a downstream farmer who's got a surface extraction permit will have no idea which water is permitted and which isn't. The senator from the 20th says, well, if it's bone dry without the augmentation, then you'll know. But that's not the only scenario in which that might happen. We are establishing a dramatic change in Georgia's water law if we give the state ownership and extinguish permitting rights below a particular augmentation point by statute like this. And then we're allowing them to put that augmentation point anywhere they want. We think maybe, although we don't know really what augmentation is going to look like. So that dramatic change in Georgia's water law is not worth it today. Let's implement the sound management policies that are in the rest of the bill. Let's, again, use your judgment on the amendments. I intend to support them. But let's leave the augmentation debate for a time when we know what we're talking about, when we've had time to discuss it, when we've had the ability to go down and assess the impact on riparian rights, and when somebody's going to be able to say this water is state water, this water is water that's permitted, and this is some other water. We've never had that before, and I don't think we ought to implement it in this way in this bill that otherwise contains a lot of sound management. So this merely deletes the portion of the bill that deals with augmentation, which we don't need, and which we're not sure the impact it will be, and which would dramatically change Georgia's water laws. Thank you, Mr. President. If there's any questions, I'll yield.
You do have a question. No questions. No questions, Senator.
Thank you, Mr. President.
Chair recognizes Senator from the 50th. What purpose you rise? Yeah, we'll get to you in just a second. Chair recognizes Senator from the 46th. Speak to his amendment.
Thank you, Mr. President. Ladies and gentlemen, I also want to commend Senator from 20th, the hard work he's done on this bill. It is important. It was established that when we originally passed the law to protect the Flint River system from drought. We have had a number of droughts in recent years, and this is very good, proactive environmental legislation to protect the water resources of our state. So I applaud him, and I commend him for what we've done here. Amendment 4 seeks to simply broaden the scope of this bill. Right now it is focused on the southern portion of the Flint River Basin, particularly concerned with agriculture. It is an entire river basin system though, and it seems to me that we ought to address the entire river basin all the way up to the headwaters that start here in Fulton County. All I'm asking for here in Amendment 4 is to add to the studies that are called for in the bill. And I'd direct you to page 4 if you're following along, starting at line 115 is where this would be inserted. You'll notice there are some studies called for in this bill, mostly focusing on the agricultural uses of water, irrigation of farmland down in southern portion of the river basin. This adds studies to look along the entire river basin, look at reservoir releases, interbasin transfers of water, return flows, and we want to also look at municipal industrial uses of water in addition to the agricultural uses of water. On top of that, in subparagraph 6, I ask us to have an assessment of additional drought management actions and funding alternatives, also looking at the entire river basin and all of the water uses from that basin, including municipal and industrial water permits. This does not change the permitting process at all. It does not create any new rules or regulations or limitations on industrial or municipal use or any economic development. It simply calls for a more thorough, complete, comprehensive study of all the water uses throughout the river basin. And finally, it asks that baselines, based on these studies, that certain baselines be established of what the acceptable water stream flow targets should be and thresholds should be. It gives them an extra year after those studies are completed in January of 2014 to come up with these recommendations. I do not believe that the author opposes these amendments. I'll let him speak to that, but I think it enhances and improves the bill by making it more thorough, more comprehensive in our attempts to deal with potential drought situations in the Flint River Basin. Thank you. President, I'll yield the will.
No questions. We do have another amendment with Secretary Reed.
Amendment 4A. Senator Harper of the 7th and others offer the following amendment to the Amendment 4 to the Senate substitute to Senate Bill 213 by striking lines 14 through 17. Through with the order, Mr. President.
Chair recognizes Senator from the 7th to speak to his amendment and defend ag.
Amen. Thank you, Mr. President. Ladies and gentlemen of the Senate, I appreciate the senator from the 46th bringing this amendment forward, but I do have an issue with one portion of the amendment after discussing this one with others, and it would be the bottom portion of the amendment, lines 14 through 17. I would like to see this strike. I don't think we need to be establishing flow targets. I think we get into a lot of issues and a lot of unintended consequences if we go down this path. I believe that this is something that we need to make sure that is taken out, especially when we're looking at the interest of our agricultural folks in southwest Georgia, and more specifically South Georgia and rural Georgia, because we don't want to be setting baselines. We need to let EPD to continue the authority to do that, and under this we would require EPD to establish those thresholds. I would rather have the EPD the authority. If they needed to establish those thresholds, they could do so under their own will, and if we implement this, we would require them to establish those thresholds. So I would respectfully ask for your support on this amendment. It is also supported by the chairman of the committee. Thank you very much, Mr. President.
You do have a question if you'd like to answer a couple. Let's see.
I'll take one.
Okay. Chair recognizes Senator from the 22nd.
Thank you, Mr. President. Senator, do you yield?
I yield.
I appreciate the senator from the 20th bringing this important measure to us, and certainly the concerns around this amendment. My concern as it relates to your amendment would essentially be striking Section B of the amendment that you're speaking of. My concern is it not true that in the statewide water management plan of 2008, that part of the authority that was promulgated over to EPD was in fact to establish flow targets for each of the river basins that are in fact part of that management plan? And what's happening here, so I'll give you a chance to answer that.
I'll be honest with you, Senator, I'm going to revert to your knowledge of that, but I would also revert to the chairman of the committee's knowledge, and I would defer that question to the chairman of the committee whenever he comes and closes debate, if that's okay.
Okay, I'll take that. Yeah.
Senator has yielded. The senator from the 36th, you had a question. He had yielded the well. It was good.
He yielded the well?
Yes, he'd yielded the well.
His amendment surely can withstand scrutiny. Well, should I could I ask you a parliamentary inquiry
You
then?
sure can.
Thank you, Mr. President. As I understood it, was this Amendment 5 that he was speaking to? Or
No, this is Amendment 4A.
4A.
4A. This is amending 4.
That's right. Thank you. And isn't it true that if you passed 4A, if you voted yes on 4A, you would be disadvantaging actually the farmers and all those that depend on that river flow, because this would create a transparency situation where the government determines appropriate flow targets and thresholds and announces them, and they're there for everyone to see. Wouldn't that be the wisest approach, which the original amendment number 4 would put into place?
Now, the Flint, we're talking about the Flint River Basin, correct?
That's right.
And is that in Atlanta?
Actually, the top of the Flint, yes, originates in Fulton County,
Okay.
where I'm elected to serve. Thank you for that inquiry.
All right, very good.
Yes, and actually the thrust of this Amendment 4, as I understand it, is it not true, would do the studies up and down the entire Flint catchment area, the Flint Basin.
I think the author will be able to address the issue.
Thank you.
Question is, you want to deal with the southern end of the Flint, or do you want to make this a statewide issue that has not been through the committee process? This is a whole nother issue and a huge expansion to what has been agreed upon by various entities. The chair recognizes the senator from the 50th, and then the senator from the 20th closed debate.
Mr. President, members of the Senate, now I want to tell you up front that I can't answer a lot of the technical questions about this bill, so when I sit down, you can turn to the person next to you and say, he didn't know what he was talking about. But I want to tell you 2 or 3 things that I do know on a real serious note. When I got in politics, someone told me one time that you could make a career out of politics out of being against everything. It's always easier to be against things than it is to be for them, and you can always say, well, I have a little problem with that. Well, I do want to tell you why I think it's important for you to vote for this bill. Agriculture is important to our state. I'll tell you the things that I do know. Agriculture is important to our state, and water is very important to agriculture, and this affects southwest Georgia. And if you pass this bill, I believe it'll provide adequate water for southwest Georgia. It deals with the Flint River Basin. The other observation that I would make is I haven't sat through those hours of testimony. I don't have the expertise the senator from the 20th does, but I know that he and members of the agriculture community who are a lot brighter than I am have studied this issue and studied this issue and studied it, and they brought this bill, and the agriculture community is solidly behind it, and I trust their judgment. With that said, Mr. President, I'm going to yield the well.
Chair recognizes senator from the 20th close the debate.
Thank you, Mr. President. And y'all, I know that you don't know. And I don't know everything, but I know I've sat through 5 billion hours of water policy work, okay? I done been rode hard and hung up wet. And so I'm going to go through these amendments. I think everybody has really good intentions on all these amendments. I don't question anybody's intentions, but we're talking about delicate policy here. Amendment number 1, I say vote for that. That's including a water policy center that deals with agricultural water policy, and I want them involved in the center from the 12th. We want them involved in this water policy work that is so important to agriculture down that southwest Georgia region. Amendment 2, I would say do not vote for that. I understand what the senator from the 19th is saying. I understand that. And we don't do aquifer storage and recovery, and we're not going to do aquifer storage and recovery unless sound science, studies of sound science say it's a good policy. So it's not in the bill, it ain't in the bill, and it ain't in the bill. But I'm telling you, you got to put that sound science together to know whether that will actually be a good tool to use in the toolbox, and if it's not, it won't be used. So no on number 2. The intentions are good, and I understand the senator from the 19th's intentions. But the reality is you don't know the facts. So don't go outlawing something you don't know the facts on. We're not using it today. We're not going to use it next week, next month, and next year. But we need to study and get the facts. Amendment number 3, augmentation is extremely important. And the augmentation that we're doing is part of the study of the system and how that whole system works with itself, from groundwater to surface water, and how that flows together and what kind of impacts it makes. So I say no to number 3 because it is important that we have that tool to do the science on to understand whether it's the right thing to do or not. If we shut it off, how are we going to know? We've got to study it. 4A, I'm for 4A. 4 is a good, I have no problem with 4. The problem was the bottom end. Those stream flow targets are going to be set over time. But you're mixing the upper and the lower Flint right here, so I think the bulk of the number 4 amendment is good. I don't have a problem with it. I'm telling you, studying every square inch of the Flint is a good idea, and I'm for that. I'm just saying that we need to take out that bottom piece, that little section B down there at the bottom from line 14 to 17, and let the studies occur. Let the studies occur where we can decide how we need to set those stream flows and those targets. They're going to be set. The statewide water plan says they're going to be set. These studies will show where they need to be set at. And I'm for that, and I think that's good. And so the senator from the 46, his amendment is a good amendment. Other than that one little bottom piece, we need to take it out so that we have the ability to get those flow targets where we need them and then set them. And that is the end goal, Senator from the 46, is to get those flow targets set so we'll know where we need to go. So 4A is a yes, and 4 is a yes. Ladies and gentlemen, please follow me on this. This is complicated, very difficult policy. It's not emotional. You can't use emotions with it. So if you will, vote for amendment number 1, no on amendment number 2, no on amendment number 3. And those amendments have good intentions, and I understand those intentions, but we can't afford it right now. And then yes on 4A and yes on 4. With that, Mr. President, I would yield the well. I'll be glad to take a question if we need to. But understand, y'all, this is very sensitive policy for this state and for the Southwest Georgia region.
No questions, Senator. Thank you.
Thank you. Please follow my instructions, please.
What he meant to say is please support the chairman. All right, the question is on amendment number 1. Amendment number 1. Everyone follow along, please. Amendment number 1, authored by the senator from the 12th, that has the author's support, is not objecting. Is there objection? Without objection, amendment number 1 is adopted. Now the question is on amendment number 2. Amendment number 2. Is there objection? There is objection. There's objection to amendment number 2. Chair recognizes Senator from the 20th. What purpose you rise?
I just question, I mean, it's all water policy, but I do question whether aquifer storage and recovery is not in this bill, okay? So you're amending something into this bill that there's not in the bill. And I don't know if that'd really be germane at the end of the day. I mean, it all deals with water, but it's not in that bill.
Ruling on germaneness. Chair recognizes Senator from the 20th. I mean the 19th, excuse me.
Parliamentary inquiry, Mr. President.
State your inquiry.
Aquifer storage is a form of augmentation which is in the bill. This just clarifies that form of augmentation, that's an add to the bill, can't be used to augment.
Now, Senator, your amendment says no well or borehole shall be drilled or used for the purpose of injecting surface water into any aquifer in the state of Georgia. Is that right?
Senator, Mr. President, augmentation is when you add water to surface water.
I'm aware of that.
What the intent of drilling into the ground is to put surface water in the ground to use later to augment the flow. That's the purpose of putting the water in the ground in the first place. This would prevent you from using that type of water to augment by not allowing you to drill the wells in the first place for those purposes.
All right, I'm going to look at the question on germaneness, and I understand. Chair recognizes Senator from the 20th. What purpose you rise?
Thank you, Mr. President. I would ask y'all to please not vote for that. And the reason is studies will be conducted over the years ahead, and if the sound science is not there for aquifer storage and recovery, it will never be used in this state. So we need to have the ability to make that study. If you shut down the ability to make a study, then you're not willing to look at the sound science.
Chair recognizes Senator from the 19th.
Mr. President, we've done this before. We have disallowed the use of aquifer storage over in the adjacent basin because we were concerned about it. This just says that you can't use it in Georgia now, but some future point in time.
I understand. We're not going to. We've had a long, lengthy debate on this issue. Senator from the 20th, are you wishing for me to rule on germaneness, or you want to vote on it?
I would, but I'm telling everybody that the only thing that we've done on aquifer storage and recovery is on the coast, and that's because of the salt water intruding in the aquifers.
Right. We're all into that.
All right.
We're getting into a whole host of other issues and trying to make this bill into something that it is not.
Well, I would ask you to rule on it, and we'll go from there.
Okay, this is the posture. I could easily rule this amendment not germane. Number one is it is adding in Section 7. The amendment itself is not drafted to encompass what the title of is in the actual the bill. But I'm gonna go ahead and let you guys vote on it. So all those in favor of amendment number 2, authored by the Senator from the 19th, rise and stand and be counted. If you're in favor of amendment number 2, rise, stand, and be counted. Reverse. On amendment number 2, the yeas are 22 and the nays are 19, and amendment number 2 has been adopted. Question now is on amendment number 3, authored by the senator from the 42nd. All those in favor, rise, stand, and be counted. If you're in favor of amendment number 2, authored by the senator from the 42nd. 3. Reverse. On amendment number 3, the yeas are 18, the nays are 30, and it has lost. Now the question is on amendment 4A. 4A, authored by the senator from the 7th. All those in favor, rise, stand, and be counted. Rise, stand, and be counted if you are in favor of amendment 4A, authored by the senator from the 7th. Reverse. On amendment 4A, the yeas are 26, the nays are 21, and the amendment has passed. Now the question is on amendment 4 as amended. 4 as amended. Is there objection? Without objection, amendment 4A, or 4 as amended, is adopted. Now the question is on the adoption of the committee substitute as amended. Is there objection? Chair hears none, and the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed. The Porter Committee which fail to pass the bill. Chairs none. Porter Committee is agreed to. Shall the main question be now put? All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. On the adoption of the bill, the yeas are 52, the nays are 1, and this bill, I'm sure, constitutional majority is therefore passed. Secretary will read Senate Bill 85.
Senate Bill 85 by Senator Bethel of the 54th and others. A bill to be entitled an act to amend Article 2 of Chapter 34 of Title 43 of the OCGA relating to physicians so as to authorize the administration of vaccines by pharmacists or nurses pursuant to vaccine protocol and for other purposes. The Senate Committee on Health and Human Services recommends that this bill do pass by substitute. The Health and Human Services Committee offers the following substitute to Senate Bill 85. A bill to be entitled an act to amend Article 2 of Chapter 34 of Title 43 of the OCGA relating to physicians so as to authorize the administration of vaccines by pharmacists or nurses pursuant to vaccine protocol agreements with physicians and for other purposes. Through with the order, Mr. President.
Chair recognizes the Senator from the 54th. Present the bill.
Thank you, Mr. President. Members of the Senate, I bring to you Senate Bill 85, which resembles Senate Bill 288, which we passed last year by a vote of 43-7. This bill increases access to health care for Georgians, improves the public health, and lowers the cost of health care for all Georgians. This is about real solutions. Thankfully, we don't have to debate whether or not we support the federal Obamacare or Affordable Care Act, because this is about solutions in Georgia for Georgians. Let me give you an example. The day this act becomes law, anybody who's a TRICARE plan participant, their copay for a vaccine when they go to a pharmacy in Georgia becomes zero that day. That's already the rule for TRICARE. It's just not the rule for Georgia. That's real solutions for Georgians. I want to thank the chair, the senator from the 45th, for working on this bill. We have improved it over the version we passed last year. She convened a stakeholder meeting. We had folks at a roundtable setting talking about the issues we had in this bill. We have improved this bill by adding language that relates to a medical home. Different from last year and this year's bill is that if a patient seeks to have their vaccine record reported to their physician, if they ask their pharmacist are required to report it there. Of course, they're already reporting it into the database. 38 states exceed Georgia's version today of pharmaceutical vaccination. If we pass this law and it becomes law, and pass this act and it becomes law in Georgia, they will still exceed the threshold in Georgia, because they allow all vaccines from the CDC panel to be administered to adults and adolescents. This bill does not go that far. I ask for your favorable consideration. Mr. President, I would yield the well unless there are questions, and I'd gladly respond.
You do have a question from the senator from the 53rd.
Thank you, Mr. President. Senator, yield.
I yield.
Now, there's some chatter back here. So are you saying that this is going to be a money-saving thing for patients and people of all occasions by passing this bill?
I am, Mr. Chairman, thank you very much for the question. It does so in two very noticeable ways. The first is that we, based on the only real evidence that's available to us, estimate about an 85% discount to the payer for vaccines in a pharmacy setting. The second is that based on increased vaccination rates, we'll have less sick Georgians, which also saves all of us time, money, resources, less absenteeism from work. So yes, sir, it does save immediate dollars for payers in Georgia, be that insurers, be that employers, and most importantly, be that patients.
No further questions, Senator.
Thank you, Mr. President. I urge your favorable consideration.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed? Report of committee which fail will pass the bill. Chair hears none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair has none. Main question is ordered. Shall this bill now pass? Question on the passage of the bill. All those in favor will vote aye. Those opposed, no. Secretary unlock the machine. Chair recognizes Senator from the 7th.
Parliamentary inquiry, Mr.
State
President.
inquiry.
Is it not true that I was planning to ask the senator from the 54th about his bill, and for my benefit only, that the vaccines that we're about to allow the pharmacists to use would not stunt the growth of individuals?
I don't think anybody's growth will be stunted, nor has yours. Yeah. On the passage of the bill, the yeas are 46, the nays are 7, and this bill, AMC Regs constitutional majority, is therefore adopted. We're going to take a 15-minute recess. Be back at 5:30.